And may I be permitted to mention, my lord, this is my lord, a hearing matter 2018, my lord, regarding my lord pension and arrears salary and my lord leave encashment not released, my lord.
Give. My lord, this matter relates to all non-payment of terminal benefits.
Yes, Mr. Bhattacharya.
Yes, I am mentioning item number 300, praying for upgradation
Why?
due to the reason that petitioner was an employee of the West Bengal Essential Commodity Supply Corporation of the undertaking of West Bengal, my lord. He tendered resignation in the month of July, my lord, upon giving 3 months notice period that expired on October, my lord. Thereafter, he, in spite of several representation, no release order has yet been issued. In the meantime, petitioner participated in the interview process and he has been selected for appointment. Appointment order has been issued.
Somewhere else.
He is unable to.
Somewhere else. Appointment in somewhere, some other organization.
Yes, KMC, my lord. He has selected and but unable to join.
Give the number. Give the number, serve notice upon your other side and
Yes,
keep a watch on the list.
Yes, I have given the notice.
Don't give the notice, only the mentioning slip you give.
Right.
And intimate your other side also.
My lord,
My lord,
Not from behind. That is not the way. A senior is standing in front of you.
my lord, I mentioned the matter.
Is it your personal matter?
It is my personal matter.
What is it?
It is my lord, that I have already.
Where is your matter?
New motion. It is a new motion.
Give the number. Give the number.
It is new.
Listed motions, please hand over the slip.
thank you. Grateful, my lord.
How many are there?
20.
20. What are these matters?
Non-payment of terminal benefits, my lord.
All.
All.
New motion. Lordship for
My lordship,
inclusion, lordship.
for inclusion, my lordship.
Motions, please hand over the slips.
Inclusion?
Give.
Inclusion.
My lord, may I be permitted to mention on contempt application? My
Yes, application.
lordship, may I be permitted to mention?
Application.
Lordship application, lordship.
Lordship, may I have your lordship kindly, my lord.
Hello.
Madam, may I be permitted to mention that it is a pension matter, madam. He is not getting in pension. It's 24 matter, madam. Related appear.
My lord, may I give a matter for a restoration?
Hand over the slip for application. New motion.
My lord, may I be permitted to mention?
candidates.
Motions, it will be.
My lord,
It is there in the monthly.
You want upgradation?
Yes, your lordship.
my lord, may I be permitted to mention on matter, madam? My lord, the petitioner is suffering from
What do you want?
my lord, urgent hearing, my lord. It is running in the monthly list, my lord. Item number 312, my lord.
So you want upgradation?
Yes, my lord.
It number tell don't call.
My lord, may I?
Application. Withheld candidates.
I have mentioned.
You mentioned
My lord, may I?
application.
My lord, may I have your kind leave to mention a matter for inclusion, my lord?
Another upgradation. My lord.
What is the promotion that is going on? What is the problem over there? Any issues?
বেরোতে পারছে না
My lord, with your lordship leave, my lord, I mentioned two matters for upgradation. Now, first one is, my lord, for conclusion of a departmental procedure.
Give the number.
My lord, another for, my lord, I'm prolonged suspension, my lord.
Give the number, please.
May I be permitted to mention, my lord, that health assistant female, but fresh matters. If your lordship kindly fix it, my lord, 8th is the date. My lord, I have given in the presentation form.
You give the number, let it appear, then I'll see what is to be done.
8 tarik.
2012. I given notice already. And another is original.
At the time of hearing, original side, please hold on. At the time of hearing, your adversary should be there.
Yes, Mr. Everything is.
Ex party hearing will not be taken up.
My lord, may I have your lordship kindly?
Given
Two matters, my lord. One is, my lord, I was superannuated.
I do not know. I do not want to know.
Hearing matter, my lord. I was superannuated 2000.
Already you give the number in case.
Listing, my lord. Because matters are not hearing matters, my lord.
Already you give in case it appears. I'll see.
Notice, my lord.
Why? Hand over the slip.
Contempt application.
Hand over the slip.
There is a matter. The matter is ready for hearing, but we have made an application.
My lord, may I mention a hearing?
All slips you'll hand over. I'll see what is to be done with them.
Matter I have mentioned on the earlier occasion, my lord, this is pensioners, my lord, from Bose Institute, my lord, they are 7 CPC, my lord,
Hand over the slip.
2020 hearing, madam, my lord, some proceed.
Hand over the slip.
So,
Matter related to equal work and
Yes, please. Hand over the slip. Give.
there is a matter related to equal work and equal pay. My lord, this was remanded back by the division bench. My lord, 2 months direction was given, my lord.
Sir, hand over the slip.
May I be permitted to mention item number 273
Hand over the slip.
for upgradation, my lord.
Mention it on top, upgradation. It will be taken
Lord.
care of.
Inclusion of restoration, inclusion of restoration application.
I'm maintaining for updation.
My lord, original side hearing matter also inclusion.
Just wait. You mentioned on top upgradation?
For upgradation.
Yes, give.
If the matter was in the determination of Ogata Bhattacharya under the list of hearing, also order has been annexed. So due to inclusion the matter.
Hand over the slip.
That's like 2 matters for hearing, my lord. These
Hand over the slip. I'll see what is to be done.
contempt matter, my lord.
Give. Call the list, please. Original side. Yes, give.
My lord, I am
Original side hearing matter for
Give.
I am permitted.
How many are there?
2 matters.
2 matters.
Similar.
May
Alright.
may I permitted to mention, my lord, regarding item number 88, this is education matter.
88.
88.
88 released from the list for want of determination.
Page 186. Page 186.
88, please release. Call the list, please.
My lord, only one prayer, my lord. My lord, only one prayer, my lord. Serial number 260. Well, a similar matter, similar relief has been granted by your lordships. I am only seeking similar benefits. The posting of health assistant females to their home district. Mariam Khatun's matter and also Ranu Hajira's matter, my lord. Serial number 260. I have given the slip for upgradation, my lord.
You've mentioned upgradation?
Yes, my lord.
All right.
For
inclusion of contempt, my lord.
It's over. No
I
further.
couldn't enter.
Next, no.
Couldn't enter.
I don't believe. It's
17 lordship.
it's vacant for quite some time. Again,
No,
next
because
month.
the page wise was going on then, but I
No page wise. All wrong information.
page 88 was
Sorry, all wrong.
real 88. Okay.
Nothing doing. Yes, please.
I got wrong.
Yes, petitioner. Original side.
My lord, I am appearing on behalf of the 8 petitioner, my lord.
Yes, please.
Last occasion, direction was passed. Regarding the pension and gratuity manner that was released. The husband of the petitioner was an employee under the
ECL. Who is appearing? You are there for ECL. All right. Why is it not been released?
We have processed pilot,
Come before the microphone, please.
Kindly come to the report, pilot. Or kindly see, the regional officer, they have
Did you get a copy of the report?
last day report was served to me, my lord. But there is no they have said so that they have already
Let him say what he's got to say. Yes, please.
But we have, as far as we are concerned, ECL is concerned, the giving pension, is this, authority, is my friend, that is Coal Mines Provident Fund, we have processed everything, and kindly see, they have also asked for some clarification that also have been given, I have annexed everything,
Page.
Kindly see, from page 8,
How soon is he going to get it?
Releasing authority, is my friend can answer. Releasing, my friend can answer. But there is one issue over
Is
here,
it only the provident fund amount or something else?
Provident fund amount, the genuineness of certificate, but there is some question with regard to the genuineness of that person, who is claiming, If your lordship sees,
But genuine, it is you who have to ascertain.
but we have informed, there would be 2 persons in the name of Zumi Major, So, my lord, what we did, my lord, we asked the, my lord, the district magistrate and the police authority to verify that same, my lord.
Yes.
You kindly see, my lord, that letter, my lord, at page 11, my lord. Kindly see. This is to the Commissioner of Police, my lord.
Yes, September 2025.
My lord.
So we are in April. You must have got the report.
Yes, my lord. That report have kindly comes, my lord.
Other benefits are already been released
That
in favor
report,
of
my
the
lord, page
petitioner.
30. Page
There
30,
was
my
no
lord.
necessity to.
Can you see, my lord?
Page 13. Yes.
During last paragraph, I'm just reading, my lord.
Hmm.
During inquiry, the EO means my investigating officer, my lord, could not learn about the CA, character assassination. That means character assassination subject to the police verification of relationship. In this regard, EO collected a self-declaration. So return this paper as unverified. What happened, my lord? When the inquiry officer went to them, my lord.
No, no, this is September. We are in April.
Yes, my lord.
What has happened?
But till that, this is the report.
No, you cannot keep this lady waiting for more than 6 months.
Well, other benefits has been released in favor of the petitioner, man.
My lord,
Only for pension.
verification, my lord. Okay. My lord,
Gratuity provident fund was released.
this, my lord.
Not, this is not the provident fund dues. This is the pensionary
Yes,
dues.
ma'am.
Provident fund you've received.
My lord, claim that they have received.
Gratuity also received.
The claim, my lord, they have
Actually,
received.
that is controlling authority. This one number 10.
Then-
Appearing on behalf of CMPFO, this one number 9.
But the releasing of
Actually, we
pension,
are
my lord,
the
would be done by
disbursing
my friend.
Disbursing authority of what?
of the
Pension.
gratuity, provident fund and pension.
So she has
We
got
have-
it.
We have disbursed the amount of provident fund long time back. And recently, we have also disbursed the pension amount.
Now it is it is your turn.
Pension amount has been released, my lord, then there is nothing to
It is-
be done in this matter, my lord.
The
Because
latest instructions I have received just now
but
over telephone.
this case, my lord, his claim is only for pension, my lord. If
Yes.
the authority is
Pension
saying that
benefit
everything
released.
has been released, my lord, then my lord,
Pension
that is
benefit released.
this petition is exhausted. my lord.
Pension you are holding back.
But I can't hold, my lord. This is with the CMPF, my lord.
No, no.
What we will do, my lord, we will only, my lord,
We can't disburse the pension.
that we have done, my lord. Now he's saying that the pension has been released, my lord.
Yes, yes, yes. As per
Pension has been released.
No.
pension released. This is the latest
I'm not
instructions.
That is the problem.
getting any information.
When has the pension been released?
I'm telling you.
In my account, my lord, no payment has been made by them.
Have you got the latest bank statement?
Yes.
Show me.
You tell me when it was released.
Yes.
Pension is released.
ফোনটা কাটুন না আগে নাহলে আসবে না তো
No, no.
হ্যাঁ
Please come.
1,67,919.
Area pension has been.
Area pension.
The petitioner
না previous court মালা directed
Claims-
them to
claims
submit.
pension.
একটা কবে, তাই তো?
33/2026.
30th of March.
30th of March
It's
2026.
very recent.
Recent. মানে I have not received any
No, no.
amount.
Mm,
He was then take
Um,
instruction.
Is this the widow pension or the
No, my lord, this is
I
a
mean,
bit.
arrear pension?
Yes.
अच्छा কি বললাম claims arrear pension due to
Area and the well, area
current pension.
and now he is now
That
in
means
the
the widow
age of his
pension.
60 years he will get the pension amount.
Petitioner receive
The
Widow.
soft copy of the release amount. I have
pension amount. Pension amount.
Area and pension.
Arrear and current. Both arrear and current. Both arrear and current. In respect of her deceased husband,
we have
who
disbursed
was
an amount of
serving the Eastern Coalfields Limited. Stuff.
disbursed
Learned
amount of-
advocate representing the respondent numbers 9 and 10, being the pension sanctioning authority, submits upon instruction that pension has been released, arrear pension has been released in favor of the petitioner on 30th of March 2026. Stuff. Learned advocate for the petitioner is not aware of the same. Stuff. Release the matter for further consideration on 20th of April 2026. Learned advocate representing the respondents shall produce photocopy showing payment to the petitioner. Stop. Learned advocate for the petitioner shall also obtain necessary instruction in the meantime.
My lord.
Report filed by
But
ECL.
instead of 20th, can it be next week? Because 20th, probably I shall not be here. on 20th.
You have it now.
Yes.
I'll keep it then prior to that, 17th,
No, sir. Either prior to 10th or prior to 22nd.
22nd. So many days. The court is running and you will not be here. Keep
Okay,
somebody here.
Okay, I will appear through video conference.
Yes, please do.
Yes.
When 20th?
Okay, 20th.
20th. And hand over a copy to your learned friend prior to that.
Yes,
The
yes,
soft copy, give it to him.
I'm just following.
Yes, next. What is this for?
This is the matter relating to the release of amount of MMCC.
MMCC.
Monthly monetary cash compensation that has not been released. My lord.
The same problem, my lord, verification, my lord.
No, but then how long will you take to verify? You cannot hold on
Give us 2
for
weeks,
eternity.
give us
2
2 weeks.
months?
2 weeks, 2 weeks.
2
My lord,
weeks.
we'll again write later to the
All right.
my lord, and thereafter, my lord, we'll.
The petitioner prays for monthly monetary compensation.
Cash compensation.
Cash compensation from ECL. Stop. Learned advocate representing the respondent seeks time to revert with instruction. 20th, same.
This is also the matter relating to the claiming for amount of MMCC. This is also another matter. That is the
Yes.
claiming for amount of MMCC.
Your instruction.
In this matter, just see all the respondents, including petitioners, are outside the jurisdiction of this original site.
All right.
All are from the Asansol area.
And my
All
lord,
right.
It should have been filed in appellate side jurisdiction.
All right.
my lord, the order has been passed on 3rd December 2025 by Honorable Justice Shogata Bhattacharya. The petitioner is Semgita Bori, but where they in that matter, the petitioner is claiming for MMCC and either MMCC or employment. Where the Honorable Sogata Bhattacharya has observed and passed the order that all the respondents are situated outside the original jurisdiction of this court. So he has furtherly ordered that the matter should be transferred from original side to appellate side.
What is the merit of the matter? Why is she not getting the MMCC or employment?
This case belongs to area of pension.
This is for pension.
Yes. No,
All right.
pension. This is relating to the MMCC.
MMCC. Yes.
Area pension.
532.
Page 22. Prayer F.
Yes.
The respondent withhold the aided pension amount and the other terminal benefits of the petitioner deceased husband and further be directed to pay the monthly pension month by month to the petitioner along with 12% interest to the petitioner immediately.
Yes. What is your instruction?
My lord, in that case, my lord, we have to file executive opposition.
There is a two petition, 1531 and 532. 532 is coming before the Lordship's court, and 531 is separate. This is claiming for pension and gratuity amount, and this is the amount claiming we are claiming for.
Are you there in WPO 532?
Yes, madam.
All right. And regarding the transfer from original side to appellate side is a technical matter. I want to know about the merit. What has happened?
My lord, in that case, my lord, we have to take instruction.
Why did you not take it? It was filed long time back and you are aware of it. Then you should have been ready with instruction. Or you just say that it will go from appellate side to original side to appellate side. That is going to help you out.
My lord, give us short time. We shall come back with instruction.
This matter was taken up in January, in February, again in February, and now.
My lord, this matter today is first time.
No,
Several.
I can see orders over here. How can it be for the first time?
2025 is pending.
Please come. From the cause title of the writ petition, it appears that the parties fall outside the jurisdiction of the original side. Step next. In view, the respondents raise an objection with regard to the maintainability of the writ petition in the original side. Step. Accordingly, let the writ petition be transferred in the appellate side. Step. The On transfer, the writ petition shall be renumbered. Stop. The writ petition in the original side shall be treated as disposed of. Stop. Learned advocate representing the respondent seeks time to revert with instruction as regards the MMCC claim of the petitioner. April 27th, a report by ECL shall be placed before this court on the adjourned date.
But I am for the petitioner.
Yes.
But there
My
were,
lord, I am appearing on behalf of a state, my lord.
but there were two writ petitions in file, one of 2025 and another of 2026. So far as the writ petition of 2025 is concerned, but I have prayed for disbursement of retirement benefits, including provident fund and gratuity leave encashment. But so far as the writ petition of 2026 is concerned, but I took a prayer for conversion.
No, but then this is not the 26 petition. This
No,
is the 25.
may I just indicate to you? 2026 is concerned, that stands disposed of withdrawn. I have prayed a prayer for a CPF to GPF for conversion of contributory provident fund to general provident fund. The earlier coordinate bench directed, since it matter relates to the disbursement of retirement benefits, that writ petition was sought to be withdrawn and liberty was granted to file a supplementary affidavit in the writ petition of 2025. That supplementary affidavit I have filed in the writ petition of 2025 before your lordship. But there was a direction to file a affidavit in opposition to the supplementary affidavit. But
Not to the main writ petition.
main writ petition,
Madam,
whether
main
reports in the form of affidavit has been filed both by the state respondent and the transport corporation.
My lord, the supplementary affidavit, my lord, the AO is to be filed, my lord. For that, I require 1 week's extension, my lord.
My lord, West Bengal Transport Corporation is only killing the time of the honorable, available time of the honorable court, my lord. My lord, please come to
My lord, two contradictory claims were
my
made.
lord, please come to the page number 10 of the writ application of the petitioner, my lord.
Yes, please. Yes.
This is 10 para A, my lord. This is the prayer of the petitioner, my lord. And a writ in the nature of the amendments commanding the respondent and or each of them to pay and disburse the provident fund amount along with 10% following the date of retirement till date of the actual payment, my lord. This is the prayer of the petitioner. My lord, again, please come to the page number 4 of my report in form of affidavit affirmed by the respondent from my end, my lord.
Is the report there? State's report. Page 4, yes.
My lord, page 4,
Hmm.
paragraph number 6, last from the bottom, my lord, last paragraph. That in relation to the petitioner retirement benefit, the admissible dues include provident fund, gratuity and leave encashment as detailed in the statement of retirement benefit for June 2025. Next page, my lord, which are fully supported by verified claim and proper disbursement procedures. A. Designation tram driver. B. Provident fund dues so and so lakh rupees. Gratuity so lakh 9,70,096 rupees. Leave salary, leave enhancement 4,42,500 rupees. Total demand amount which I paid to the Transport Corporation 24,15,411 rupees, my lord. Thereafter, my lord, look into the paragraph number 7 that I state and submit that funds corresponding to the aforesaid retirement benefit were duly sanctioned and released by the Transport Department by sanction cum allotment order memo number so and so, my lord, dated 26 June 25, my lord. By virtue the said sanction order, a total amount of rupees 2,71,33,971 only was released for payment of the retirement benefit of 19. It might be they have asked for 30 or 40 employees, but already 19 employees retirement benefit I have released. Please come to the page number 9, my lord.
Yes.
This is the memo.
All
where
right, I
have
got it.
released
I have got it. When will this money be paid?
My lord, there are
My
two
lord, my
aspects
lord,
of the.
my
No
lord, please
aspect.
again look into
This
the page
amount
number
has
13,
been
my lord.
sanctioned by the state in your favor.
My lord,
When will it reach
my
the
lord, a
petitioner?
part of that amount has already been paid to the petitioner. The petitioner is
much?
also admitted in the writ petition, my lord.
5,48,700.
Out of 2415?
Out of 2415.
5 paid.
Yes, 5,48,790.
All right. Balance 19.
My lord, the claim was for 7 crores. We have been sanctioned
I do
2
not
crores.
know. When will you pay?
My lord, let the state, my lord, release the balance amount.
Very well. In one of the matters in the appellate side, I had freezed the salary. I'll do it in this matter also.
My lord,
Because it is long time.
My lord,
No
will,
questions.
my
If
lord
it
will-
has been
my
paid,
lord-
nothing doing. No, sorry.
My lord
Please
will
come.
kindly considers, my lord, there are
Nothing
two
doing.
aspects of the writ petition. My lord, the petitioner has made contrary claims for which the supplementary affidavit has been filed.
Whatever
My
the
lord-
state has
my lord,
admitted
if
his
this
claim.
is- my lord, if this is directed, my lord will only listen to me for 2 minutes. My lord, if this is
If the
directed,
state has admitted the claim, why are you saying it is contrary?
because, my lord, perhaps the learned advocate for the state is not aware of the writ petition of 2026, which was withdrawn by the petitioner and the supplementary has been filed. My lord, by the writ petition of 2026, the petitioner had claimed for pension. And by the writ petition, which is before your lordship today, my lord, the petitioner had prayed for provident fund. Now, my lord, these two claims are contrary, which was taken note of the Justice Shogata
Listen,
Bhattacharya.
thing is, pension is not there. Provident fund has been sanctioned. If the provident fund had not been sanctioned,
My lord, the provident fund has not been sanctioned.
yes, it is the provident fund dues is mentioned over here.
The provident fund has not been sanctioned, my lord. The retirement, my lord, a total claim for issuance of the retirement benefits were made. My lord will kindly,
9,78,981.
my lord will kindly comes to my report
I have
once.
sanctioned, my lord.
If the transport corporation and the transport department is at loggerheads, that is your problem, not the employee's problem.
No, we are not at loggerheads, my
My
lord.
lord, please come to the page number 30. Look into the page number 13, my lord.
978 has already been sanctioned. It says
My
provident fund dues in full.
My lord will kindly comes to paragraph number 11 of my report, my lord. My report.
Yes.
My lord will kindly sees, my lord, that a proposal was made for an amount of 7 crores 15 lakhs 8887 towards the payment of provident fund, leave salary, gratuity, and other arrears. The name of the petitioner is appearing at serial number 6 of the said requisition dated 5th June 2025 as against an amount of rupees 24 lakhs 15,411.
My lord, this is
However,
not a matter of 7 crore or 8
1
crore.
minute, please wait, please wait. State, please wait. Let me hear what the corporation has to say. Yes.
However, a total amount of rupees 2 crores 71 lakhs 33,971 was only paid by the respondent number 1 as against the claim of 7 crore 15 lakhs 80,000 and odd, my lord. Now, my lord, the state has also admitted it in their own report that they have paid only 2 crores instead of 7 crores. Now, my lord, of the 2 crores that we have received, my lord, we have made part payments to all the retired employees. Now, my lord, some part payment has been made and some part payment is, my lord, pending because of the pendency of the other part of the payment requisition that we had put up across the state. Now, my lord, as soon as we receive this part payment,
So that means there is no contrary claim. You say that
no,
money
contrary
is
claim
not
is
there.
My lord will kindly comes to the my lord will kindly comes to the order of 25th February 2025, my lord. Passed by this honorable court, my lord, and this with regard to this writ petition, my lord will also considers the supplementary affidavit filed by the petitioner in this writ petition. The petitioner by the supplementary affidavit has prayed for
that is merely at the prayer stage.
Yes, but that writ petition was moved when it was
very well, still at the prayer stage.
My lord, then the supplementary affidavit may be withdrawn so that I do not also have to my lord, deal with that. I can only deal with the provident fund part. The pension,
whatever is there is on record. The state has said that yes, this is the claim of provident fund admitted and some payment made to you. Whether you get 7, 2, 5, it is between you two.
My lord,
That
of
is not the
sum payment,
problem.
my lord, I have also disbursed the payment, my lord. I could not disburse the entire payment, but a part payment has been disbursed. Now, my lord,
So
will
that
kindly
means you
consider,
say that because of paucity of fund you cannot pay.
my lord,
That
because
you say,
my lord,
and it is for this reason that you give time to the employee to come up with other inconsistent pleas.
my lord, the requisition was made to the state even before the petitioner had retired. Even before 1 month before the
So it
petitioner
is
had
your
retired.
problem. That is not the problem of the employee.
My lord, I completely understand
Then
that.
why will the employee suffer? You are compelling the employee to come to the court only for receiving the terminal
My lord,
dues.
we are
Is it
also,
proper?
my lord, we are also at the, if not at the same footing, but at a similar footing, my lord.
All
We are
right,
also
go and
dependent.
fight. Why don't you sue the state? Go sue
My
that
lord,
the state
my
is
lord,
not giving me
this-
fund. That is the reason I cannot pay my employees.
my lord, this situation was taken into consideration by this honorable court. My lord,
Everything is known to everybody. Even then, no payment is being made
lord,
and parties are directed
my
to
lord
come
will
to court.
kindly consider
No
schemes were,
consideration.
my lord will kindly consider schemes were framed. My lord, the scheme is annexed to my writ petition. My lord, the justice,
My lord, I
Bhargava
have a small
as well
submission
as
before the
justice
lordship. Kindly consider, my lord,
Sanjeev
one thing,
Banerjee, my lord, has both, my lord, taken consideration of this situation. My lord, schemes have been framed, and under the scheme, the state is liable to pay.
My lord, yes.
Go and sue. Who's stopping you?
Probably that is only the step which has been, my lord, not explored by the corporation. But my lord will kindly grant me some time. My lord will kindly,
Or the corporation will, I'm going to stop salary of the top ones.
my lord will kindly consider.
No, sorry. Why will
Grant me-
somebody in the lower rank not be paid his terminal dues? The only question that is troubling the court is this.
My lord,
Nothing
I
else.
completely understand the
No,
trouble.
then you understand, you keep it to
My lord
yourself
will
and speak to your clients. I'm not
My lord
concerned.
kindly
No,
grants
come.
me, my lord will kindly grants me 1 week's time, my lord. May I come back?
Come back with a report that you've paid, otherwise salary is stopped. The petitioner is a retired employee of the West Bengal Transport Corporation. His provident fund dues. Gratuity did you receive?
No. Gratuity, gratuity 9,70,096.
Nothing.
Only 5,48,790 has been.
And the breakup is not there.
Breakup has not been given.
My lord, one small submission allowed me, my lord. My lord,
Statement
please
of-
come to the page number 13 of my report.
Statement of calculation has not been provided.
You will get everything in
No, his
which
terminal
account I
benefits,
have paid, what amount I have paid.
including provident fund dues, not including, comprising of provident fund dues, within bracket full, comma gratuity, comma leave salary / leave encashment, amounting to total 24,15,411 was due. Stop. Learned advocate for the petitioner submits upon instruction that out of the aforesaid dues, a sum of rupees 5 lakh and
48,790.
48,790
Yes, my lord.
has been paid. Stop. The balance is due. Stop. The petitioner retired from service
On 30th
On-
June 2025.
30th of June 2025. Stop. He has been compelled to approach this court only for the purpose of getting his terminal dues released. Stop. As per law, comma, a retired employee is supposed to be paid his terminal dues immediately upon retirement or soon thereafter. Stop. It will be nearly a year that the same has not been cleared. Stop. Paragraph. The affidavit of the state respondents mentions that funds corresponding to the retirement benefit of the petitioner was sanctioned and released by the Transport Department in June 2025. And a total amount of rupees 2 crore 71 lakh 33,971 was released by the Transport Department for payment of retirement benefits to 19 employees, including the present petitioner. Stop. As per the state, upon release of funds, the state's financial obligation was fully discharged. Stop. The Transport Corporation has filed a report mentioning that a requisition for liquidating the dues of the employees, including the petitioner, was forwarded to the Transport Department, seeking for an amount of rupees 7,15,80,887 towards payment of provident fund, leave salary, gratuity, and other areas. Step. Out of the aforesaid claim, a sum of rupees 2,71,33,971 has only been sanctioned by the state. Stop. For want of balance fund from the state, the terminal dues in full cannot be released in favor of the petitioner. Stop paragraph. The corporation has averred that from time to time requests were made to the state for releasing the dues, for clearing the retirement benefits of the retired employees. But for scarcity of funds, the payment of the petitioner cannot be made. Stop paragraph. The stand of the corporation for not releasing payment in favor of the petitioner cannot be accepted by the court. Stop. The employer would be bound to release the terminal dues of the retired employee. Stop paragraph. The matter is made returnable on 4th May 2026. Stop. In the event the balance dues of the petitioner are not cleared prior to the adjourned date, then the salary of the respondent numbers 3, 4, and 5, the chairman, managing director, and the chief accounts officer of the West Bengal Transport Corporation shall remain frozen.
Deeply obliged, my lord.
আমাদের তো লিস্ট কল হবে এক মিনিট ডাকুন দেখি কি বলছে
But I'm for the petitioner. And I have served notice before mentioning the matter before your lordship. And
who is appearing?
Madam, from the order sheet it appears that Mr. Amul Kumar Sen and Shobhoshachi Mondal is appearing for the CSTC, but I have approached him. He refused to take any notice, saying that he is no longer in CSTC. But thereafter, I have sent the letter to the managing director. Upon that, I mentioned before your lordship. After your lordship accepted my mentioning, again I have some notice that the matter will be appearing today before your lordship, but no one appears.
Right now, who is appearing?
But on the last date.
Show the copy of the notice.
My lord, may kindly see the last order of 5th March 2024. Before the coordinated bench, it was represented by Mr. Shane and Shobhoshachi.
No, he is not there.
Not there.
So
Subsequently,
the
my lord,
new
one
council,
Kahini Shumi appeared for CSTC.
But for this matter, my lord, Mr. Bhattacharya has not been.
then maybe somebody else has been briefed.
Madam, kindly see the last order of 18th March. 18th
Yes.
March, Miss Sahani Shumi, advocate for the CSTC, appeared in a GI application filed in
No,
connection.
but then she will also possibly not appear because they are all from the team of.
That's why I have served notice upon the managing director itself.
Check up with Mr. Bihani if he appears. All right.
My lord.
None appears on behalf of the respondents despite notice. Let the notices filed in court be taken on record. Stop. Let further notice be issued. Stop. Release 20th, 20.
May I serve a notice upon the managing director again, my lord? Because
You can serve him. You can contact Mr. Bihani also in case he appears.
my lord, grateful. Much obliged.
Next.
For the petitioner, my lord, Mr. Partho Ghosh is appearing in this matter. He is contesting, my lord, assembly.
Accommodation has been sought for on behalf of the learned advocate who is representing the petitioner. Stop. List on 8th of June.
Senior counsel Mr. Shomo Mojumdar and Mr. Rutikanto Pal both are appearing before courtroom number 13. I am seeking a short passover or not today.
Passover will not be possible. It's already time. So I make it only not today. All right.
I'm for the
But I am for the petition. But the
Is it the
affidavits have been-
same thing?
No, affidavits have been completed. It can be taken up for hearing.
Who is the other side?
My lord, Niladri Bhattacharya, assisted by Devolina Chattoraj, same person who appeared on the last occasion.
Ms. Shotoraj was here.
Yes, yes.
This matter, will you be appearing? Bihani is leading you? Yes, so. Is not here? All right, it is time, so I'll make it not today only. Let it remain in the list.
My lord.
Animesh Babu.
Number one. Sorry, monthly list.
The Lordship, I am for the petitioner led by Mr. Shonak Ghosh. He is engaged in code number 15. I am praying for very short Passover, Your Lordship.
I see it was disposed of in February. Why has it been mentioned?
Mentioned because they have filed an application, but not for recalling. They stated in the recording application, they stated we are not willing to deposit the amount.
Which amount?
Getting the pension. That was what has been ordered.
Yes.
They said that we are already in UPS, so we are not supposed to deposit anything. That is their case. But can you keep the page 8 of the application?
But how can this be done in this manner as to be mentioned?
On the previous occasion, I mentioned it for correction, your lordship.
What is the correction? Tell me, what is the correction that you want? It was mentioned for correction. I can see your slip over here for correction. But what does it, what is the correction that you want to make? Not ready?
Your lordship.
Why? Should have been ready. What is your name?
Shubha Gayan, lordship.
I see your signature. You mentioned the matter. Then why should you not be ready? Why is the junior not ready in the matter?
Sorry,
Is the brief with her?
it's with her, but probably she's ready, but probably she's being a junior member, she could not express herself properly.
Not a word has been mentioned about the merits of the matter. Please train the juniors in such a manner that if the senior is engaged, the junior can carry forward the matter till such time the senior comes and takes over. How will she learn if you do not allow her to open her mouth? What is it for? What is the correction that you want?
This is for recalling, my lord.
The matter was mentioned, and I have the mentioning slip where it is mentioned for correction. You did not mention that it is an application for recalling. Do not try to mislead the court.
Probably the person who has mentioned, I do not know, may have made an inadvertent error. I do not.
Inadvertent error. This is coming from a chamber. If there are four counsels, cannot make four different submissions.
And I am a counsel engaged. I'm from a solicitor firm.
I do not want to know what's happening in the back office. I have the mentioning slip over here, which is mentioned for correction. What is the correction? There is no correction to be made. There is an application that is you have filed. It will appear in the heading application. Why did you waste the court's time?
And I cannot.
Next month. List in the next month under the heading for application.
I am for the learned advocate last occasion you heard the matter, for I was not present at that time, your sister adjourned for the day, and fix it today. Yes, my submission is there, the unemployed youth, who has dependent ailing brother and a handicapped uncle. And on that respect, his mother has come, pension, after the consideration of the bank authority by submitting the provident fund money. Inter provident fund money refunded back, and after that he got pension. And later on, he has get ex gratia lump sum amount on the basis of compassionate appointment.
Your application,
yes,
very first one, writ petition stood dismissed. The next appeal stood dismissed, confirming the order passed by the learned single judge, right? You have come up with the same prayer all over again. This is an abuse of the process of law, and the court has disclosed in the order that the court will impose cost for wasting the court's time.
My submission was there, there is order was there, because ex gratia lump sum was paid on the basis of compassionate appointment, but he in the order sheet, that was another matter. Ex gratia lump sum.
I do not know. I will see the order sheet. I will not go behind the screen to find out what is there and what was submitted. That is not possible. I can see that you have grossly abused the process of law, and you have at least given some idea to the client that yes, there is a scope for getting an order. That is the reason a third writ petition has been filed, despite the claim being dismissed on the very first occasion.
That should be my bank. I do not say anything, just say kindly. My submission.
No question of kindness. pay cost.
No, it's a kind of unemployed youth, my lord, I am, my lord, not placing this application, my lord, please. Otherwise, my
It cannot be.
yes, my lord,
It cannot be.
but this is the situation of my
If
client, he's
court
unemployed.
permits, if the court permits, you have taken money for filing the writ petition. It is not that you've done it for free. You induce the client.
Only cost
Yes.
has been taken, my lord. I
Whatever.
have taken my
Why?
cost.
Even that is a wastage of the person who is an unemployed youth.
Previous occasion that has been highlighted on this respect. I am
Nothing doing.
I am not.
Come on.
I am not suppressed. I am.
Allowed to place certain judgments of the Honorable Apex Court wherein it has been categorically held if any particular material document has been withheld from the court that amounts to perpetration of fraud not only on the opposite party but also on the court itself.
And what is the document that he has withheld?
Lordship, with regard to the single bench order as well as the division bench order.
Copy you have produced, but in the writ petition it has been mentioned.
It has been averred, but it has
Then-
not been enclosed.
Yeah, I can get it from the internet. The server copy I can get it. It is always on record. It is not that the petitioner has suppressed it at all. Petitioner has not suppressed. Copy has not been enclosed. That is different. That I can still consider. But then the conduct of the petitioner cannot be.
But my
Acha.
submission already as a kind.
I have
am
got
not
the
facing
submission made on
the other
behalf of the
client who is suffered, my
petitioner.
lord. So he's unemployed youth, my lord, depending one ailing brother. His
The
regular expenses is there, my lord, and
the,
handicapped
um,
uncle is there. So you have to kindly. I am not placing this application. This is,
even knowing all these things, you come up with this type of a plea.
this is my submission.
Why will this court allow it?
Please kindly consider. my
Not
lord.
press.
It's kindly not pressing, my lord. You have to
Acha.
kindly consider.
কি বললাম? Her submission on the issue of imposition of costs for gross abuse of the process of law. Step. It has been submitted that the petitioner is an unemployed youth and it will be absolutely impossible for him to pay the costs if directed. Stop. If imposed. Stop. The mother of the petitioner is also not in a position to.
Mother has died, my lord.
Mother died. Acha. Who is there?
Only son, my lord. Elder son is only, and her younger son is ailing son, and he's my client is.
The petitioner has an ailing brother
and handicapped uncle.
And an handicapped uncle who the petitioner has to take care of. Stop. Prayer has been made not to impose any costs. Stop. The petitioner also seeks to withdraw the writ petition. Stop paragraph. As the court has spent considerable amount of time in hearing the parties, the court is not granting any permission to the petitioner to withdraw the writ petition. Stop. The writ petition stands dismissed. Stop. On the prayer of the petitioner, costs is not imposed, but a caution is given to the petitioner not to file writ petitions in gross abuse of the process of law. Dismissed.
Yes, great.
Lordship, I am the petitioner.
Yes.
Your Lordship, in this matter, the matter has come up at my. Your Lordship, we had faced a termination by the petitioner. The petitioner has been acquitted by the criminal court. I wanted to place that on record. This is regarding a disciplinary authority on account of which the petitioner was suspended earlier and thereafter terminated. But on the same cause of action, an FIR was lodged in which I have been acquitted. I wanted to place that acquittal order by a way of a supplementary affidavit. I have served my learned friend by email the supplementary. I shall hand over another copy as well. Your Lordship, my client is presently not in Calcutta. It is ready, but it couldn't be affirmed.
Show me the proceeding in the initiated by the bank, the disciplinary proceeding of the bank.
Your Lordship, the show cause notice is at page 85.
Tell me first, what is the connecting application for?
Your Lordship,
I can see one can appropriate order.
To my best, with reference to a wakalatnama, it has been disposed of as I'm instructed.
Can has been disposed. It is still showing in the list.
Pleadings have been completed. I filed my
Past
affidavit.
necessary allowing the applicant herein to cancel the wakalatnama filed by him in writ petition and wherever learned, namely Horishankar Chattopadhyay, was engaged.
That
has fresh wakalatnama been filed?
Your Lordship, Your Lordship. The advocate on record is over here as well. He's present in court.
All right.
Page 85 is the show cause notice, Your Lordship. What had happened, Your Lordship, that I am a bank employee. I had, under the instructions of the chief manager, I had inquired into the loan accounts of one Mr. Respondent number 9. Abhijit Srivastav, Mr. Srivastav. From paragraph 4, I have pleaded that in 2019, the chief manager, UCO Bank, instructed me to conduct an inspection in the district of Bakura. And accordingly, I had conducted the inspection thereafter and filed a report. Thereafter, another report was made for the Lion Band branch, and I had also filed a report to that effect. And wherein I had indicated that there are lots of discrepancies in the loans granted by Mr. Srivastav, and accounts have been given, 8 lakhs, 12 lakhs accounts, monies have been given, wherein the bank has suffered losses. Your Lordship, this report was submitted long back. Thereafter, in 2019, an FIR was lodged against me by Mr. Srivastav itself, that one Guddu Kumar was blackmailing him to submit that the inquiry that has been initiated against respondent number 9, Mr. Srivastav, that can be taken care of him if he gives him some money. And for that purpose, he had called him to KFC Havra to give the money. He paid 5,000 rupees. Thereafter, there was an amount that had to be paid, 50,000 totally. So that was not paid. So he took him to the ATM, and there the officers of the bank were there, and he was, police was also there, and he was arrested from the ATM. And this Guddu Kumar is a third party, nowhere related to me. And the report, which was against Mr. Srivastav, that was already submitted to the bank long before. That I have also pleaded in my writ petition at
But from what you submitted just now, I can understand the contents of the FIR, the allegations therein, and the disciplinary proceeding are separate.
Your Lordship,
the allegations in the show cause, the charges that have been brought against you, and the allegations in the FIR are different. They are not the same.
Your Lordship, I was not named in the FIR.
Yes.
Because the FIR was against a third party. Thereafter, when the charge sheet was filed and the case was initiated, I was made accused number 2 therein on the basis of the witness, Mr. Srivastav's, and others' statement. In the criminal, so the charge sheet, the FIR may not be the same, but the charge sheet and the criminal investigation was on the same cause of action. That whether those documents on basis of which Mr. Guddu Kumar was blackmailing Mr. Srivastav were handed over by me or not. Those documents were already in bank's possession, so there cannot be any question of me handing over because that was on bank's record. So these were all, and in the evidence before the criminal trial, we had produced those documents, and on merit, we have been acquitted by the
Very well. That's then automatic. Your acquittal in the criminal case does not mean that your disciplinary proceeding goes automatically. It doesn't go. Where is the punishment order?
Your Lordship, the last termination order is at page, it's of 29th September 2020 at page 185.
Did you prefer an appeal?
Your Lordship, I preferred an appeal. I preferred a
Lost.
review as well.
That also lost.
Your Lordship.
All right. What is the error on their part?
Your Lordship, I had asked for certain documents which I have also annexed in my that I had asked for the documents. Those documents were also not provided. And I had at page 87, I had asked for the documents, and my appeal is at page 198. Page 196 is my grounds of appeal before the appellate. They have not placed no proof by Srivastav for having received any mail in his own mail account from me. The case of leaking or disseminating bank internal or confidential document is between Mr. Guddu and Srivastav. I am not in the picture. I am nowhere in the case. My name does not appear either in the written complaint before the police or in the FIR. Concurring to the findings of inquiry officer, the learned disciplinary authority due his conclusion in the final order of punishment dated 29 September 2020. In this way, the leaked documents were supposedly under my custody. Such statement is conjural and capricious belief only and not in the firm decision. He further derived that either I provide the documents to Mr. Guddu or I was negligent in handing over confidential document. This is not a probability. This is also a probability. How is the capital punishment imposed on probability? The learned DA has erred in imposing a capital punishment on probability driven by impulse and not based on any material evidence. The conclusion of inquiry officer is also inference and based on suspicion, conjure, subness, and irrelevant considerations. Violation of natural justice I have pleaded because I had asked for documents that were not provided, and the inquiry officer were of predetermined outcome. They had decided it, and thereafter, Your Lordship.
How do you prove that it was predetermined?
Your Lordship, Your Lordship, I have been, because I was the whistleblower and I made complaint regarding, in my inquiry report, I gave, on basis of my documents, 2 officers were, on basis of my report, I had given that one retired employee and one Mr. Srivastav were involved in the malpractice. In my report, I had categorically stated I was made a scapegoat because I had given this report, and they have not been able to prove that I had the witness was not examined, and I was not given proper opportunity to cross-examine the witnesses to show that I did not hand over. They have not proved that I handed over the documents. It's only on the probability that these documents were in my possession. So either I was...
The entire disciplinary proceeding in service jurisprudence relies upon probabilities. It is not that there has to be conclusive proof as is required in a criminal trial. Then,
Your Lordship, there are judgments to that effect as well.
How do you get out of that?
There are judgments to that effect, recent judgments I would like to place, that if I have asked for documents, those documents need to be given to me. I had categorically applied for the certified copies of the documents which were not provided to me. So, until the documents are there and there is violation of there may be, but all the documents needs to be given. I need to be given a fair opportunity.
Which is the particular document that you are relying upon?
Page 87, Your Lordship, I had stated, please provide me the certified copy of all the related documents. And
what does this all the related? It is so very vague.
Show cause notice, all the documents that were stated I had, and show cause notice is at page 85, Your Lordship.
Did you ever specify before the authority what are the documents that you require?
And my reports, Your Lordship.
That has not been attached by the bank.
That even in their opposition, the bank has not attached those replies. My reports. that I have prepared and submitted.
No,
but
if you have submitted, that means the report is there with the authority.
Lordship, I cannot have that report because
Must be having
Lordship,
copies.
that was done from the official ID. I do not have access to it.
All
So
right.
I did not, once I was suspended and these show cause was issued, I did not have access or I could not have taken any document from the bank. So to prove my case that these were I required those documents that.
Show me that you sought for those documents.
Page 87, Your Lordship.
87, all the related documents.
Your Lordship, at page 85 is the
show cause.
Show cause. In
Right.
They have relied on the documents. That page 85 P13. So under 1 sub A, clause A, copy of the note placed before MD and CEO containing his observation on investigating pertaining to branches, copy of the note placed before CVO investigation report, letter addressed to Bishnupur signed by Sanjeev Kumar relating to documentation. You were aware of the important information and secret facts related to branches leaked out. So these are the crucial point number 2. These are the documents which report on basis of which they say that alleged that the documents were leaked out. So those documents were not provided to me, which they have relied in their own show cause notice.
Page 85 is dated 9th of August 2019. Page 87, it's your letter dated 23rd of August 2019. And then the charges were handed over to you, right? Statement of charges.
Page 90 is the statement of
charge. Yes, this is in October. You were directed to submit a written statement in defense. Statement of allegations. Where is your reply to that? Articles of charges. Conduct an inquiry. Page 96.
Page 96 is a document by which they say that I am exhibiting these documents.
Page 93. Yes, I acknowledge. Confession, I was compelled to confess. You mentioned I was compelled to confess out of fear.
Page 55 is a document by which the bank officers had forced me to make a page 56, 55 onwards is a Hindi, and the translated document is at page 88. The English translated copy. And I was in
88,
police.
What is it?
Your Lordship, the translated copy of the confession, that alleged confession, is at page, and translated copy, the alleged translation. 58. Page 58, Your Lordship. This is to place that by mistake I have given the internal and confidential documents. Page 58, Your Lordship.
Page
The confession statement. Alleged confession statement.
58.
From this time that I was under hair state police custody. That I have pleaded with the pleadings.
Yes.
Your Lordship, page 58 is
mistake. I have given the internal confidential.
Your Lordship, I was under custody when this confession is taken. I was in Hare Street Police Station under custody. This cannot be relied at all. I have also pleaded that in my writ petition in para 18 and 22.
Writ petition comes.
And even before the
How was the
Your Lordship,
authority supposed to know?
Your Lordship, even in my reply, which is at page 93, I was compelled to confess out of fear. Page 93. In my reply as well, I have stated that it was out of fear and I was compelled. It was under duress, and I do not accept that confession, alleged confession, because I was in custody at that time. And in the matter which confession alleged, it is before the police and wherein I have been acquitted.
96. 96, you submitted a whole lot of document. Not you, the senior manager of that is the presenting officer of the bank. As for notification.
Vishnupur and inspected live one branch. This is the post. Inspected live one branch.
Suspicious cash deposits in the account of Mr. Srivastav.
Was the entire case to save him. To save him.
And your lordship, the allegations
Show me
that
something where during the disciplinary proceeding before the inquiry officer you sought for these documents. One page you showed, page 87. That apart, please show me that these are the documents, particular documents that I require.
Your lordship, the allegation that are there that Mr. Guddu had passed on the documents of Bishnupur. That was another investigation which was not conducted by me. I had conducted the investigation in Layak Bunch. So I could not have access to the documents of Bishnupur. I had conducted the investigation for Layakganj, and Mr. Guddu was blackmailing him for another branch of Bishnupur, for which I cannot have access, your lordship. And I have no remote connection with Mr. Guddu.
See, the scope of judicial review in this type of proceeding is extremely limited.
Your lordship.
Right. So how much can the writ court can enter if there is violation of the principle of natural justice? Yes. You say certain documents were not given to you. What are the documents? You have not
Your
specified.
lordship, I have specified that show cause, whatever documents are relied in the show cause.
You say all documents.
Your lordship, and the show cause, they have categorically stated what are documents they had, and the report that was submitted.
When you were examined by the authority, did you mention that these are the documents I require? Which
Your
page
lordship,
is it?
on that, can I come back and satisfy your lordship?
All right.
What are the documents and in the report and cross-examination where I have placed it? Meantime, I'll also affirm my
Only
supplementary.
if there is procedural irregularity, there is violation of principle of natural justice, then only the court can interfere. Otherwise, no. If you want to come prepared, I give you time.
Your lordship.
And you also come prepared with all those judgments. Are you ready today? Because judicial review scope is extremely limited. Please come. The petitioner is a dismissed employee of the bank. Stop. It has been submitted that as the petitioner has been acquitted from the criminal case lodged against him, comma, the order of dismissal ought to be set aside. Stop paragraph. The petitioner preferred the appeal before the appellate authority challenging the order of dismissal and also before the reviewing authority, comma, but the order of dismissal has been affirmed by both the fora. Stop paragraph. The petitioner alleges violation of the principles of natural justice. Stop. To allow the learned advocate for the petitioner to come prepared with further necessary instruction. Release the matter for further consideration. When do I keep it? Fortnights?
Your lordship, fortnights.
20th, 20.
Your lordship, instead of 20th, instead it could be 22nd.
All right, 22nd.
Your lordship.
Acha. Hmm. There is one can which is showing in the list. It has been submitted
has
that
become
the can has been disposed of. Huh?
Disposed of.
Check up from the order sheet if the can has been disposed of. Regarding can.
Wide order dated 19th of August 2025.
इसके पहले वाला order. इसके पहले
No, before that. Online
I do not see. I can see an order recorded 16th of August 2024. The matter was referred to the Learned Secretary Bar Association for settling the dispute. Thereafter, it has been disposed. No, that is different, but there is no recording that the can has been disposed of. I do not find it over here, at least. Check up in case it is not, then dispose it off. Next.
Obliged, Your Lordship. My affidavit of service may be taken.
Yes.
For my lord, I am for the petitioner. My lord, this matter pertains to employment on compassionate ground.
Other side.
Affidavits were exchanged, my lord. Other side is not there. I will serve notice and come back, my lord.
Who is your other side?
Mr. Bijoy Kumar.
Mr.
Bijoy Kumar.
J. Kumar. None appears on behalf of the respondents. Stop, let further notice be served. 20th of April.
My lord, perhaps my learned senior friend is not coming to court due to illness. If my lord, he does not receive, my lord, I will serve to the department directly.
How long is he ill?
My lord, I am instructed by my senior that he is suffering from cancer.
So he was not so regular. That is why.
Yes, I didn't see him for quite some time.
Yes.
So, what is to be done?
Lord, notice would be served directly to the department when.
I am also a panel advocate of ECL as Mr. Vijay Kumar, my lord. May I inform?
All right, then you take steps. I am not passing any order.
Yes, I shall inform the company, my lord.
20th, the matter is appearing, will appear. Let somebody take steps.
All
Next.
right, ma'am. My lord.
না না যেটা অর্ডার বললাম সেইটা no Nana appears serve notice no she is not appearing. Five.
Malad, this matter relates to recruitment of temporary home guard. Malad. Earlier, there is a direction of filing a report. Malad. They have already. Well, this is my exception to the report. Malad.
Yes.
Malad, and only one thing. Malad, if in the meantime the recruitment is completed, Malad, perhaps there is nothing to much.
All right.
So if you let them
Matter
take
relates to
instruction, the
recruitment.
Not in paragraph 5J already.
You have mentioned
that recruitment completed.
5J.
No, Malad, at that point in time, the recruitment was not completed. Malad, when they filed the exception.
Where, which portion?
My lord, page 7.
Oh, page 7.
J, my lord, top one. Report, my lord.
This is the exception.
My lord, report, my lord. Present.
Report page 7.
Malad, at that point of inviting applications was completed, Malad.
My lord,
not the recruitment was not completed at that point of time.
My lord, presently the procedure for recruitment of the temporary
applications
home guard has already been completed and all the eligible candidates have already been appointed. And presently there is no vacancy in this regard, my lord.
The matter relates to recruitment of temporary home guards.
Yes.
Stop. The recruitment process was initiated in the year 2022 in various districts of the state of West Bengal. Stop. Presently, it has been brought to the notice of the court that the recruitment process is long over, all appointments have been made and there is no vacancy. Stop. Next. In view of the above, nothing remains to be decided in the instant writ petition. Stop. The same has become infructuous due to efflux of time. Dismissed as infructuous. It is your name that will go down. Let him come.
I don't know, 6.
Yes.
Start, my lord. May I humbly beseech your lordship to turn off the live first, my lord.
All right. What is something sensitive?
No, I will explain, my lord. Kindly turn off, my lord.
All right.
My lord, I'm appearing for the respondent ECL in this matter, my lord.
All right. All right. The virtual hearing will continue, but the live streaming will not be there.
Great.
My lord.
My lord, if your lordship, Lord, memorandum has been passed, my lord. The persons, my lord, who are, my lord, casual staffs completed the continuous 10 years, my lord, this experience, then will be, my lord, permanently.
Where is that?
My lord, the, page 65, my lord.
65.
This is the memorandum.
Yes.
Page 65, memorandum, my lord.
Where are you serving?
My lord, Sagor Rural Hospital as a contractual staff. The post is, my lord, the sweeper. Group this.
All right.
And my the memorandum 65, and thereafter, my lord, the series of, my lord, representation.
Whether this memo is applicable?
Memo is, my lord, this 2011, 16th, my lord, this September. The relevant point is, my lord, 1, 2, 3, 4, 5th, my lord, paragraph. May I read, my lord, the casual daily considering all these things, the coordinate bench was pleased to direct for conducting a hearing of the petitioner. That has been done. What is the fate of the hearing? That
Who has taken the hearing?
They seem which.
All right, please come.
I have not been able to do that. Right.
The petitioner claims benefit in terms of memo number 9008-F within bracket P, dated 16th September 2011, issued by the Finance Department Audit Branch.
My lord. What did you call it?
regarding engagement in service till attaining the age of 60 years, as he rendered 10 years continuous service in which hospital?
Agor Rural Hospital.
In Shagor Rural Hospital. Stop paragraph. From the it appears that on 16th October 2023, the court directed the ACMOH Kakdeep to conduct a hearing and to pass a reasoned order. Stop. The hearing has been reported to be conducted, but the reasoned order is not reasoned order has not been communicated to the petitioner. Stop paragraph. The respondent number 6, ACMOH, Kagdeep is directed to forward the reasoned order passed upon hearing the petitioner in terms of the court's order. Stop. Release the matter for further consideration on 27th April 2026. Stop. As the hearing was conducted sometimes in the year 2023, the report. Now, the reasoned order the court directed the ACMOH to file a report on affidavit enclosing the reasoned order passed in the hearing. Stop. The same has not been filed till date. Stop. Learned counsel representing the state respondents has expressed his inability to file the report for want of necessary instruction from the ACMOH. Stop paragraph. The ACMOH is directed to immediately transmit the report to the learned counsel for the state for placing the same before this court on the adjourned date. Stop. The reasoned order shall be annexed with the report to be filed by way of an affidavit. Stop. Released on. When do I keep it?
2 weeks, 3 weeks, 3 weeks at least required. More, they are all engaged in the SIR and all these proceedings.
27th বলেছিলাম কিন্তু when is the election over there? 29th. I don't think he or she, whoever will be able to do it prior to that. Keep it on the 8th of May.
But my lord, with deepest of respect, my lord, I have to pray for on that day because that will not work. That was the order. Kindly, this is the order passed by the court.
In the event the affidavit is not prepared, ACMOH shall be virtually present on the next day.
Grateful to lordship.
The said officer shall act on the basis of the server copy of this order.
Grateful to lordship.
Which will be available in the website of the court. Yes, next.
7 million, I am for the petitioner with Mr. Madhusudan. Well, this is the.
I am for the state respondents.
The post of recruitment of ASHA. Well, in 2001, my lord, the petitioner before your lordship, my lord, she passed the Madhyamik examination. In 2022, my lord, a notice was published for the post of recruitment of ASHA, my lord. And on the basis of that, my lord, my client duly submitted his application and got the admit card for interview. After interview, my lord, interview was held, but after few days, she came to know that the respondent number 6 has been recruited in the post of Asha. Now, my lord, my respectful submission, if your lordship kindly come to P2, page 13.
Is anybody representing the respondent number 6?
Already, my lord, service has been made. It's a transfer brief to my learned junior, my lord. Exception has been filed. We have also filed the report has been
Exception
filed.
by the private?
No, exception was a report filed by learned friends, my lord.
No, he's for the state.
Yes.
For the state, my lord.
What about the private respondent?
Well, that I don't know. my lord, it's a-
Her presence is necessary.
Necessary.
If your lordship kindly direct, my lord, I shall again send a notice, my lord.
What does your report say?
My lord, report says the panel was prepared by following the government guidelines. There was no violation, my lord. And the select
And the
respondent
private
number 6
respondent was
joint, my lord.
a resident of that area?
No.
Yes,
no.
my lord. Kindly
That
see,
is
my
the
lord.
same criteria.
My lord,
If your
kindly
lordship
see.
kindly come to page 13,
My lord, kindly see.
eligibility criteria number 2 should be the resident of the same area, that is same village.
My lord, kindly see page 8 of my report.
Yes.
Kindly see my report, paragraph 9, I have stated.
Oh, report. Paragraph 9.
Yes.
Paragraph 9 of my report, page 5. my lord.
Yes. In the ancient case,
Voter identity card is very vital, my lord. Epic card
name of
is to be submitted for the proof of residence.
All right, page.
Kindly see page 8 for a moment. How to apply?
Page 8.
Page 8 of my report.
Yes, yes.
B2, voters identity and ration card. Card as proof
Yes,
of local
yes.
residence.
Yes.
So she was selected.
All right. Now, petitioner, please show me where from you say that she is not the resident of that area.
But that paragraph, my lord, I have denied in my opposition, my lord.
First, you show me from your writ petition where you have stated that she is not the resident of that area.
But if your lordship kindly come to page 4, paragraph 5. Page 4, paragraph 5.
Exception.
Our exception.
Page 4, paragraph 5.
Yes.
Show me that the private respondent is not a resident of the area from where the ASHA has been selected. Where have you made that statement?
For that reason, your lordship kindly give some time, my lord, I shall call.
Certainly not. You show me from here, it's a recruitment process of the year 23.
Yes, my lord.
That's correct.
Then the court is not going to adjourn. If you cannot show, I'm going to finish it off here only. Where is the allegation? There must be some allegation.
My allegation is this: he is not at all the resident.
Show
of the
me
same-
that allegation. No, not a resident of the same village. Then said in another candidate.
No, my lord, when I am reading the paragraph 5, my lord.
No, I have read it. Is not the same for which she will be selected.
My lord, middle portion.
And thereafter they said interview.
Middle portion, my lord. Like she is a resident of village Tilahir.
She has already annexed her epic card to show that she is a resident of the
That I am
place.
denying, my lord. As per this.
Epic card you are denying?
Yes.
It is not for the read code to see
Yes, my lord.
whether the epic is proper or not.
She is a resident of, in the village of.
I am submitting judgment of
Adra police station.
judgment of this court, my lord.
Yes, let me see.
Adra police station.
But following the Supreme Court judgment, page 4 of my of this judgment.
This is regarding the relative merit of the case. Which portion you want to highlight? Please come.
Judgment of 1990 of
The matter relates to appointment of Asha. Stuff. The recruitment process was initiated in the year 2023. Stuff. The petitioner participated in the recruitment process and was unsuccessful. Stuff. Her allegation is that the private respondent, who is not the resident of the area where the Asha has been selected, has been given the appointment. Stop. The petitioner challenges the eligibility criteria of the private respondent in participating in the recruitment process, and thereafter her appointment as Asha. Stop paragraph. None represents the private respondent. Stop. From the report filed by way of an affidavit affirmed by the Deputy Magistrate and Deputy Collector Raghunathpur Subdivision on 23rd of June 2023, it appears that the committee scrutinized the voter identity card within bracket EPIC, which was submitted by the private respondent as proof of her residence in the area where Asha has been selected. Stop. The village where Asha has been selected is mentioned in her EPIC. Stop.
And your lordship, interrupt you all me. Kindly see the address in the voter card.
Please show.
It's a Tilhir.
Please show.
And it's X4, page 18, bottom portion. Address Tilhir.
Yes. Goyadi.
Goyadi. Yes, Goyadi.
So Goyadi is the place where the
Village is Tilhir, not the same village. Village is different.
The recruitment
notice.
Show me the recruitment notice. Show me the recruitment notice.
Recruitment, lordship, kindly see.
Name of the sub-center is Daulatpur. Name of the village is Goyadi.
P2 ballot, page 13.
Admit card.
P2, page 13. The notice for engagement of the Asha.
P.
Number 2, eligibility criteria number 2.
Page.
Page 13.
Writ petition.
Yes, by writ petition.
Page 13, yes.
Number 2.
Number 2.
Eligibility criteria of engagement number 2.
Yes.
Should be a resident of the same area village for which she will be selected as mentioned in Annexure C. Column 4.
Yes.
Not the same village.
Same area.
No. Within bracket village. Area means within bracket village. Our village is different from the petitioner's village.
And kindly see the next page, page 14, my lord, B2.
Yes. Page?
Page 14, my lord. B2. Voters identity card, epic card.
That should be the same village.
14.
Page 14.
Huh.
Writ
Page
petition.
14,
Writ petition.
Voter identity card, EPIC, and ration card.
Yes.
Selected candidate
Voter
submitted,
identity card
submitted
shows
her.
that she is not at all the resident of the same village.
No, same area, my lord.
Where is the vacancy notice? Subcenter name of the village.
Hmm.
Goyadi.
Same area. Goyadi.
And subcenter is Daulatpur. And Tilahid.
Petitioner resides in Goyadi.
Subcenter.
I am deciding village, my lord, Goyadi.
She is also there
He
in
also
Goyadi.
Goyadi, my lord. Yes, my lord. Same area, my lord.
Till here.
My lord, same area, my lord.
No, but then Goyadi is also there. It's not that Goyadi is not there.
The village is different.
No, 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 no.
No, I do not know which is the village and which is the subcenter.
Yes, sir.
Lordship, kindly see my village, name of my village.
Here also Goyadi is village.
First title I have
mentioned.
stated name
Where
of my
is-
village.
Where is your epic card?
Well, that has not been annexed.
Then?
That has not been annexed.
Yes.
দেখুন তো কি বললাম epic village Goyadi. How do you spell it? Gaydih has been mentioned in her epic. ঠিক আছে? According to the paragraph, according to the petitioner, comma, she is a resident of the village Tilahid.
Tilahadi Goyadi.
Tilahid.
Tilahid is the respondent number 6.
Tilahid Goyadi.
The she যেখানে বললাম না, the private respondent is, according to the petitioner, the private respondent is the resident of village Tilahid. Stop paragraph.
Area Goyadi.
The learned advocate for the state refers to the epic card of the private respondent, wherein Goyadi is mentioned.
Yes, my lord.
Stop paragraph. It appears that there are disputed questions of facts as regards the address of the private respondent and particularly the village where she resides. Stop. The state respondents have come to a considered opinion that now the state respondents have verified the documents relied upon by the private respondent, and on being satisfied that she is the resident of the area where Asha will be engaged, comma, issued appointment letter in her favor. Stop. The private respondent is serving
March 23.
since March 2023. Stop. More than 3 years have elapsed from the date of her engagement. Stop. It will not be proper to interfere in the matter
But though my
at such
dismissal
a
back
delayed
in
point of time. Stop. The writ petition accordingly fails and is hereby dismissed. Next.
I'm great.
Much obliged.
Yes, I'm still.
My lord, this is my writ petition. After filing of the writ petition, my lord, correspondences have been exchanged between the parties on this issue upon directions of this court. Therefore, we have filed we prepared a supplementary affidavit annexing those correspondences, and they have filed a report. We
have not yet filed, my lord. There was
They
no
served
scope
the
to
report.
file,
We
my
have
lord. Copy served.
prepared an
And
acceptance.
my lord,
May both be.
this report
What is
was-
the matter
was
about?
dated 6th of December 2023. Copy served.
Yes. So my lord, the matter is wholly about two. হ্যাঁ আমরা একটা সাপ্লিমেন্ট আপনাকে সার্ভ করিনি
কোথায় দিয়েছেন আমার কাছে তো নেই কে সই করেছে
এই যে দেখুন আপনিই তো করছেন বোধহয় স্যার আপনার ক্লার্ক বোধহয়
আমার ক্লার্ক সই করে নিয়েছে
হ্যাঁ if that is a problem we will come back tomorrow if you do not
copy my lord is missing my lord copy is not here
All right, what is the issue about?
So my lord, the issue is very simple. This is a case of civil death because a person went missing. An employee of NBSTC, North Bengal Surface Transport Corporation, went missing for 7 years, and thereafter his family came before this learned court and asked for terminal benefits and compassionate appointment. Now, terminal benefits, some amounts have been released to us on an ad hoc basis, but our cases, and we can show by comparing their report and our exception to the report and the documents, including
copy exception
Yes.
আপনি তো বলেন সাপ্লিমেন্টারি
আরে আপনি দুটোই দিয়েছি দেখুন স্যার
Yes, please.
Yes, my lord. So once we came before once we came before the court passed directions asking them to give us, because the person the deceased wife is actually an illiterate woman, so they asked the NBSTC authority, this court asked the NBSTC authority to give us in writing what are the forms related or what are the documents that are required to be submitted to claim these benefits, compassionate appointment as well as benefits for terminal benefits. We were sent a document enlisting a list of documents. We have replied duly to that, and those are mentioned in my supplementary affidavit. Now, they have only given us ad hoc payments, and we can show from the documents, which are basically the last basic salary, that their calculation is wholly erroneous. Secondly, in their last letter, which was issued to me upon directions of this Honorable High Court, they have issued to me a letter wherein they have again asked me to submit documents to consider my claim for compassionate appointment. But that also has not been considered so far. My lord will kindly
my lord in my report my lord
1 minute. So what I can understand is you've got two claims, one for compassionate appointment and the other is the error in calculation.
Yes.
These are the things.
Yes.
You say that you filed a composite representation before the authority, which is yet to be considered.
Yes, that firstly we had filed a representation which was not considered. We filed a writ petition. The court sent us back for consideration of that representation. That representation was rejected. Thereafter, we again came to this court.
No,
and now this
representation was rejected because my lord there was no order of the civil court that it was a civil death.
All right, now it is
another thing my lord may I tell now my lord, because of long absence my lord from the my lord the office concerned, now my lord a disciplinary proceeding was initiated, and my lord the person concerned my lord the husband of the petitioner my lord he was my lord terminated from the job.
Yes,
but eventually my lord after my lord the service of this order of the civil court that it's a civil death, then my lord that termination order was my lord recalled by the authority concerned.
Yes.
And authority concerned also wrote to him that to my lord the place the requisite or fill up the requisite formalities so that all my lord the terminal benefit or whatever the my lord the benefits that should be my lord given to him, financial benefit. Now in my report my lord it is stated that at that point of time my lord except provident fund dues all the dues paid, and my lord it was stated in the my lord the report, it was signed my lord sometimes in that my lord the December 2023 that except provident fund everything my lord they paid, and my lord so far provident fund my lord, it would be paid very soon, it was there. I think by this time paid, I think after, because we are in 2026 now. My lord point says that there is a my lord exception. My lord exception according to them my lord it was received by my clerk sometimes in January 2026. Now my lord if that is so my lord then my lord, I have to go through the exception, and my lord it is at Kuch Bihar, the North Bengal State Transport Corporation. So my lord after interacting with them my lord may I come back so far that exception with regarding the my lord their according to them there's an error with regard to calculation. My lord, may I come back after that? And my lord, so
How-
far supplementary affidavit is concerned, according to them, I do not know what is in the supplementary affidavit.
There are only 2 letters, sir.
Now, my lord, may I, my lord, file an affidavit against that supplementary affidavit?
Listen, the error in calculation,
Yes.
it cannot be rectified by way of filing supplementary or an exception.
Let it be.
You have to take a decision.
Yes. Yes.
A
If there is any, according-
whatever
my lord.
concrete decision whether there is an error.
Yes.
If the error is found, then rectify, and if it is not found, then what is the miscalculation of the petitioner?
If anything is payable after that.
And the compassionate appointment, did
My
you
lord, compassionate appointment, lordship, my lord,
Is
there
there
are,
a
my lord,
scheme?
there is no scheme with regard to, my lord, the compassionate appointment. My lord, many matters, my lord, we have, my lord, stated, my lord, before the court. My lord, in undertakings, in transport undertakings, lordship, there is no scheme with regard to compassionate appointment. Now, my lord, in many matters, my lord, we have showed that, my lord, we have placed that, my lord, in, my lord, some matters in NBSTC, my lord, a group of matters or club of matters, my lord, taken up, and my lord, there, my lord, when, my lord, the then, my lord, the principal secretary of the transport department, Mr. Bandyopadhyay, was there, my lord, he, my lord, affirmed an affidavit, and by that affidavit, it is the record of the court that there is no scheme, my lord, with regard to compassionate appointment. At one point of time, my lord, arising out of an appeal, intra-court appeal in those pending matter, which just now it is, my lord, under CAB. Now, my lord, the hearing concluded CAB, and intra-court appeal, my lord, the division bench, my lord, directed to form a scheme. Then, because of, my lord, non-implementation of that order, my lord, the contempt, my lord, the application initiated. In the contempt application, eventually the court said, very good, we are not going to this. In any event, all those points are open and to be taken before the learned single judge. And the contempt proceeding dropped. Now, before the learned single judge, my lord, in those matters, my lord, at least 7 or 8 matters or more than that, my lord, all, my lord, heard, my lord, analogously and days together, and eventually, my lord, it is now under CAB. And there, my lord, prayer.
So compassionate appointment, we are not entering now.
My lord, just one thing I would like to place. Just one thing. My lord, kindly takes up page 4 of my supplementary affidavit. There, if that is the stand of the NBSTC, my lord, then what is the sense of this letter sent by
All
them?
time they should
Kindly takes up page 4.
deposit the papers to be referred to the state government all the time, my lord. They are, my lord, saying this.
Papers for the job.
All right, you
Moreover, you
deposit-
are requested to submit the papers for the job under dying harness category. That is, and then they exactly specify the documents. Age.
1 minute. They may have given you letters. You show me the scheme under which you seek appointment.
So, my lord, these litigations that my learned friend was referring to, I have been able to access a few orders, and there is a single bench order of this High Court, wherein what is recorded is that there is a scheme framed, but the scheme is not being approved because of lack of funds by the state government.
That means as on date, there is no scheme.
Yes, but yes, there is no scheme in law to that extent. But my lord, there is also an observation in that single bench order, which is perhaps very important. May I kindly place this, my
No, no, just don't place. You read out.
So, my lord, I'll just read out. Just kindly gives me a moment.
What does the observation say?
So, my lord, what the observation is very important, because the observation says North Bengal State Transport Corporation has prepared a draft scheme in terms of the earlier order of the division bench. Mr.
that I mentioned.
Yes, Mr.
And my lord, the order dated 2017. Then, my lord, by an order of the division bench, and then, my lord, the
Sir, I'll
division
just
bench,
finish
my lord,
reading
dropped
it,
the
sir.
contempt proceeding.
Sir, I'll just finish reading.
Supplementary affidavit
আপনি দিয়ে দেবেন আমাকে, অসুবিধা নেই।
filed by the petitioner
Just one observation, my lord.
and the exception.
আমি পরপর বলে যাবো এখনই যতটুকু আমি জানি।
আচ্ছা, first the supplementary affidavit filed by the petitioner,
2017
the report of the respondents, NBSTC, and the exception thereto by the petitioner filed in court be taken on record. Stop. Learned advocate representing the petitioner disputes the calculation of the terminal dues of the employee. Stop. Employee on account of civil death. Stop. the learned advocate representing NBSTC seeks time to revert with instruction, written instruction.
My lord.
ঠিক আছে? When do I keep it?
My lord,
exception to the whole bunch.
after 25th, because
20?
next week, my lord, I will not.
After 20?
24th or 25th, Lordship. Next week, my lord, I may not be available.
6th of May.
6th May.
Grateful one.
Great.
My lord, I'm not bothering my lord
And
today.
my lord,
anymore. I'll come back and satisfy my lord on compassionate appointment next.
And my lord, may I have a copy of, my lord, extra copy of that exception?
Yes,
affidavit?
certainly.
That is
Exception
not
as well as supplementary will
Please.
serve you second time.
আমি তখন আমি জেরক্স করে নিচ্ছি
বিশেষ
না দিলে তো আমি এখানে পাঠাতে
কপি কপি আছে
Lordship, I'm for the petitioner. The last option, Lordship.
Respondent ECL, item number, respondent number 1 to 8, my lord.
All right.
There are some other private respondents as well.
10 and 11.
Wakalatnama has been filed? Wakalatnama, did you file your Wakalatnama? 9, 10,
My lord,
11?
today I just got power.
Today you got the power, 2023 matter. Your client did not enter appearance earlier.
Lordship,
It in the department.
Lordship, there is an amendment of cause title. The matter firstly appeared in 2023. Honorable Justice Arindam Mukherjee directed to add them as a party. After that, they were added as party. Yes, Lordship.
Achha. Yes. 9, 10 and 11. All right. What is your grievance?
Lordship, the mother-in-law of the petitioner was employee of the Eastern Coalfield Limited. He died in the year 2011. After that, the husband of the petitioner applied for the compassionate appointment, but subsequently he was also died. And now the petitioner before you, she is a daughter-in-law of the deceased employee. So the daughter-in-law was fully dependent on her husband, and husband also dependent on the mother. But subsequently, the husband died. Now she made representation before the ECL authority. ECL initially in the year
for what? Representation for what reason?
representation for compassionate appointment.
All right.
The
Financial benefits, did you get anything?
not yet.
Not yet.
Not yet.
All right.
Lordship. Initially in the year 2012, the ECL authority rejected their
One
claim.
minute. 9, 10 and 11, who are they?
They are the daughter, married daughter of the deceased employee.
Married daughters. All right. Now did you apply for compassionate appointment?
Yes, Lordship.
Where is the consideration? Did they consider?
No, Lordship.
They
They
did
have
not
rejected.
They
They
have
have rejected.
That means they have considered and rejected.
They have considered and rejected.
Where is the rejection?
Lordship, initially they have rejected in the year of 2012. That is in page 19, Lordship.
When did the employee die?
2011, 8th
8th of
March,
April.
8th April 2011. Initially they have rejected, but subsequently they sent a representation that they are considering, they are forwarding their claim. After that, the petitioner submitted
Where is
all
the
the
rejection?
documents.
Rejection.
Initial rejection is page number 19. Initial rejection. And final rejection is page number 30.
"19" is the rejection.
First rejection, Lordship.
Yes.
After that, they have considered, they forwarded the claim. The
Page
petitioner
number
submitted
30.
Page number
Final rejection, where is it?
30.
30.
3030. Last page of petition. এটা প্রথমটা। Lordship, kindly come to page 22.
All right. So daughter-in-law is not eligible for appointment as per NCWA.
Yes, Lordship, that is their version, Lordship.
Show me your version.
Yes, Lordship, this is a order, a copy of the order.
Now tell me one thing. Did the private respondents lay any claim for compassionate appointment?
They are the married daughter. So they have no objection if the daughter.
I have no objection.
None of the daughters have any objection if the daughter-in-law is provided appointment.
Yes.
All right. Yes. Is this the NCWA?
Yes, Lordship.
All right, 9.5.
NCWA 9.5 employment. There's clause 2, para number para number 3.
Yes.
In case of the death and total permanent disablement due to the cause other than mine accident and medical unfitness under clause 9.4, if the female dependent is below the age of 45 years, she have the option either to accept the monetary
Where is the
compensation.
definition of dependent in NCWA?
Lordship, right now I don't have that, but
That is the most important thing. Show me that a daughter-in-law can be treated as a dependent in terms of the scheme.
Lordship, daughter-in-law is an indirect dependent. I will indirect dependent, not comes under the direct dependent. So daughter-in-law direct dependent is the son and daughter, but here the son is died, and subsequently daughter-in-law applied for the compassionate appointment.
The NCWA ECL.
My lord.
Do
May I
you
assist,
have
my lord?
indirect dependent also?
They in case there are direct dependents, there is no scope for forwarding the claim to the indirect dependent. Even if there is no objection, it's in lieu of monthly mandatory cash compensation, my lord. Employment in lieu of cash compensation. So in case somebody is not interested from the direct dependents to be employed, the cash compensation claim should be proceeded, my lord, as per my humble submission, my lord.
Lordship, right
my
now,
lord, I shall assist who are the
What is your
dependents.
age now?
There is no scope for the daughter-in-law, my lord.
Right now,
As my lord
What is your
rightly pointed out.
34.
Are you within age? Below 45?
Yes, below 45.
That means there is scope for appointment.
My lord, the scheme does not permit, my lord.
MMCC in lieu
You are-
of appointment.
Are you okay with MMCC?
MMCC.
So it is not that you have to get engagement employment.
No, I am right. Currently, I am ready for MMCC.
Yes, MMCC, the petitioner is willing, and the
Yes, my
direct
lord.
dependent is not.
They can apply for it, my lord. Only difficulty is, my lord, here another claim shall come, my lord. I shall honestly submit before my lord what is going to happen, how it goes with other petitioners as well, my lord.
Right.
They pursued the claim for employment till date, my lord, and now they are changing their stance from the claim of employment. They will change to MMCC. Now they will come forward with 18% or any other percentage of interest on the arrears, and they will be claiming on the date of death, my lord. Now that difficulty will come before the authorities, my lord. I leave up to my lord what my lord decides. But my lord, this is a difficulty that is going to come forward with this.
All right. Where is your application for MMCC?
Lordship, I have not given the MMCC application name.
But the Lordship, that the writ petition that has been filed in the alternative MMCC if employment not provided.
Where is that?
My lord, that's the judgment that I have cited.
Not the judgment. your application.
The application that I've claimed for, employment, definitely, employment.
But now you want to change your stand.
This is an agreement, subject to correction by your lordship, National Colleges Agreement, Colleges Agreement and agreement. It is, that the authorities are bound either to provide employment in the even no employment provided. So monetary compensation should be provided to the petitioner. This is mandatory, if otherwise eligible, So, if in the event, even I don't apply it for monetary compensation, even then I'll be entitled. In the writ application,
You are not a direct dependent. You are an indirect dependent. It is only on the death of your son that your claim comes in. When did your husband die?
Died on October 4th, October 2011.
Your mother died on 8th of April 2011 and the son also died?
6 months after.
October 2011.
Death certificate
already
annexed.
Death certificate also,
Death certificate.
My lord, if my lord permits, may I submit one more thing, my lord?
Yes, please.
My lord, the point is whatever MMCC or whatever cash compensation is to be provided, it will be jointly provided to all the legal heirs. All the legal heirs. After that, they can decide whom to transfer it and what to do with it, my lord. But all the legal heirs are equally entitled to the cash compensation.
And that's what my humble submission before lordship, that since the other dependent, so far as the married debtors are concerned, and as per National Colleges Agreement, they have no right to claim anything. And as I've got instructions, they have no objection if I get monetary compensation, And we are ready to, the other defendant, as indicated in the constituted, the married daughters, they're ready to submit the no objection before the authority concerned, So on that score, no dispute is there,
Please come. The mother-in-law of the petitioner was an employee of Eastern Coalfields Limited. Stop. She died in harness on 8th of April 2011. Stop. On her death, her son, that is the husband of the petitioner, applied husband of the petitioner became eligible for being considered either for employment or for the monthly monetary cash compensation, MMCC. Stop. The son of the employee expired on 4th October 2011. Stop. The son was completely dependent upon his mother, and the petitioner was entirely dependent upon her husband. Stop. On the death of her husband, the petitioner seeks terminal benefit as indirect dependent of the deceased employee. Stop. Paragraph. The private respondents, being the married daughters of the employee, are represented in court by the learned advocate. Stop. It has been submitted that the private respondents do not have any objection if the employer provides terminal benefit to the petitioner either in the form of employment or MMCC as per National Coal Wage Agreement within bracket NCWA. Stop. Paragraph. The application of the petitioner seeking employment was rejected by the authority in April 2012 by holding that she was not eligible for the claim, being the claim stop. No reason was mentioned as to why the claim of the petitioner was rejected. Stop. The petitioner thereafter prayed for grant of the other terminal dues of the deceased employee. Stop. The
Lordship, kindly page number 22, Lordship.
the authority sought for certain documents from the petitioner for processing the claim for documents from the petitioner by communicating letter dated 16/18 May 2017 for processing her claim for employment. Stop. The petitioner forwarded all documents in response to the said letter, but thereafter there was no reply from the authority. Stop. The petitioner has thereafter been intimated the decision of the authority taken in the year 2023 that the daughter-in-law is not eligible for employment as there is no scope to offer employment to the daughter-in-law as per NCWA. Paragraph, the petitioner is aggrieved by the same. Stop. It has been submitted that as per NCWA, the employer would be bound to either offer employment or pay MMCC. Stop. The petitioner is agreeable to either of the two. Stop. Paragraph. As it appears that the petitioner is agreeable to accept MMCC in lieu of employment. Accordingly, the employer is directed to process the claim of the petitioner for grant of MMCC in accordance with NCWA at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. The dues of the petitioner shall be released without any further delay. Stop. Writ petition disposed, affidavit of service taken on record.
One indulgence, my lord.
Record one more thing. The petitioner shall be intimated the formalities required to process her claim. Yes.
My lord, the date of payment, initiation of payment, my lord, as I mentioned, she will be pressing for her claim for MMCC from present date. My lord, now comes
Why
the point
from present
which
date? From the date of death it will be, because that is
Alright.
your NCWA.
Yes, my lord. Let it be defined, my lord. Otherwise, it will be, my lord.
The benefit shall be payable on and from the death of the employee.
It's of interest, it is concerned 6% generally the interest rate in the earlier judgments. As your lordship, it's up to lordship, Lord.
But then see, 23 it was
Your lordship,
rejected.
It's
And you
not
will get it from 2011.
lordship, Lord. As your lord, I'm grateful to you.
And my lord, one more point, my lord. The legal heirs, all the legal heirs need to comply with the procedure. not only the
I have-
petitioner.
All right. The legal heirs. The petitioner, including the other legal heirs,
My
shall
lord, deeply
comply the
obliged.
formalities.
Deeply obliged. my lord.
Come last. Last.
My lord, for the petitioner, my lord, Mr. Atul বিশ্বাস is appearing in this matter, my lord. He's on his legs, my lord, and just praying for not this week.
Either proceed or dismissal. Choice is yours.
My lord, there was one direction on the last day, my lord, to serve upon the respondents, my lord. Your lordship gave a verbal instruction, my lord. We have served, my lord, but it has not reached yet, my lord. As per the
What is your prayer?
my lord, can we
No adjournment at all. Writ petition was filed in 23. Where is your affidavit of service? Not here.
my
I
lord,
can
affidavit of service, my lord. This is the affidavit of service. my lord.
Yes. I can see from the orders recorded, at least 4 orders, the court has expressed agony, the manner in which the petitioner has proceeded. You sought accommodation on all occasions, each and every occasion. What is the matter about? To appoint the petitioner number 2 on compassionate ground in a suitable post under the judgeship of Howrah. It's a matter of compassionate appointment, and it is quite shameful that you are going on adjourning the matter from 23. Compassionate appointment on what ground?
My lord,
Petitioner number 1 joined in 1991. Since the date he is discharging,
cerebral attack.
suffered a cerebral attack and was admitted. So the petitioner number 1 is still in service,
My lord,
right?
my lord.
Ultimately, extremely deteriorated, he became a patient of paralysis, could not join his duty. Remaining on leave for 8 months, resumed in October. Discharge functions, right? Had ability were if declared by the board not to proceed for voluntary, then permit him to proceed. Said representative received. He was deemed to retire from 31st of October 2021, although he was declared unfit on June 2021. What is your normal date of superannuation? Petitioner is Kumarish. What is your age? 58 years. Show me that you will be entitled to get the benefit of compassionate appointment.
My lord, I have not been briefed in this matter. I have just asked to
All right.
seek for an adjournment.
So I am dismissing the matter.
My lord, kindly pass it over, my lord.
Pass over. Bring your learned advocate. Yes, call the next matter.
May it please your lordship.
Lordship, my humble submission is that I'm appearing on behalf of the respondents. I'm senior
Which respondent? Union of India?
I missed my brief today.
Which respondent?
Lordship, I missed my brief. Union of India.
Union of India.
All respondents actually.
All respondents. All right. Just wait here. Yes. What is the matter?
Milord, BSF constable,
Hmm.
service terminated.
Yes.
Without a departmental proceeding.
Without departmental proceeding. Very well. Then?
Now, Milord, lordship will kindly.
Did you appeal?
Milord, here we had appealed. That has been rejected.
Rejected.
And therefore
Review?
I'm before my
Revision?
revision. We have not.
There is a
don't think
provision for
BSF
revision.
But
Where
Milord,
is the order of the appellate authority?
appellate authority's order is, Milord, at page 23rd June 2023, page 33.
23rd June 20, disposal of petition submitted. Prolonged absence. Yes.
Milord, he is not even the competent authority because the Deputy Inspector General is not the competent authority. Appeal was to the
The initial authority, the commandant was the competent authority, is the disciplinary authority, right? And thereafter, the next senior is the
next is
appellate authority.
Inspector General.
The deputy inspector is not the competent authority.
Because the appeal is page 28, not appeal.
Page 28. Show me that rule 22. The appellate authority.
28 capital A.
28 capital A.
Lordship, as per my instruction,
One
DIG
minute.
will be appellate authority.
Any petition whose considered by the order of primary person in this chapter.
Inspector General.
Present a petition to the Director General. In case of an enrolled person. Present a petition with. You say it's in case of an enrolled person. He was already dismissed. Why will it be the IG?
Yes, Milord, because
You were no longer enrolled. Oh, as per your instruction, who is
DIG is
DID?
appellate.
Yeah, show me under which provision of law?
Lordship, today I have missed my brief. That's why I'm praying for adjournment, Lordship. I missed my brief, Lordship.
All right, please come. I keep it tomorrow.
Yes, Milord.
Day after tomorrow, Lordship. That's day after.
Day after tomorrow.
Day after tomorrow.
All right, day after tomorrow. List এর নিচে লিখে দেবেন. Order দেওয়া দরকার নেই, day after tomorrow. Call the next matter once.
Lord, let it.
Day after
Tell it-
tomorrow.
Yes,
It will be there.
I'm great.
Yes. 12.
Time for the petition.
Yes. What is the matter?
The payer of the petitioner, my lord, is for fixing of the pay of the petitioner in the scale of 9,300 to 34,800 with GP 4,600. my lord, with effect from 1/1/2006. My lord, this is the third round, my lord. Earlier two occasions, my lord, this honorable court has remanded the matter to the authorities for deciding the issue. My lord, kindly comes to the order at page 58.
The authority has rejected.
Yes.
My lord,
Who will appear for the institute?
I appear for all those.
Or you appear?
well,
All
firstly,
right.
my lord, this honorable court directed the director to consider the case, but this has not been considered by the director. The deputy director has passed an order. So I've taken a point of jurisdiction, my lord. My lord, when the court orders a person, he has to.
Yes.
My lord, secondly, my lord, the aspect of great pay is what the court has remanded the matter for consideration. My lord, kindly comes to page 58. That's the order of this honorable court dated the 19th of July 2023.
Page
58.
58. Yes.
Like page 60, the relevant portion.
Hmm.
After going through the order dated 17th November 2011, passed by the coordinate bench in WP such and such, it appears the contention of the petitioner that she was entitled to a pay scale of 9,300 to 34,800 with gate pay of 4,600, being the basic pay for the pay band 2 from 1/1/2006. It was further recorded therein that the petitioner sought for a direction upon the respondent to decide the recommendation of the minutes of the meeting of the pay anomaly committee dated 10/11/2016. From the minutes of the meeting of the pay anomaly committee, it appears that the representation of the petitioner that she belonged to an isolated post and that the similarly placed officers in other institutes are holding different resignations with higher pay was considered, and it was decided to refer the case on such issue to the ministry to consider higher grade pay and change of designation of the pathology technician as technical officers. The ministry thereafter, by its order dated 19/1/2017, did not agree with the contention.
Do not go through all these things. It's a big order, I can see.
But in order to cut short the matter, may I submit?
Uh-huh.
Your Lordship, kindly on page 19. Page 19 of the writ petition.
Yes.
Prior G, my lord, my learned friend is asking for an interim order directing the respondents to permit the prisoner to accept the retrial dues without prejudice. Now, my lord, we have my instructions, my lord. She has already taken, my lord, we have already released the retrial dues. Now, as on date, my lord, there is no scope of any interim order, my lord, 7 except this G.
Yes.
So I can file my opposition, my lord, to that.
All right.
Let it be heard out, my lord.
All right. Please come. Where is the impugned order?
Case 74.
74.
Acha, the petitioner is aggrieved by the order dated 25th of September 2023, passed by the deputy director within bracket admin, ADMN, comma OFFG, rejecting the prayer of the petitioner for grant of pay grade as per pay grade. Stop. The petitioner has since retired from service. Stop. She has already accepted. She has accepted. Without prejudice.
Without prejudice.
She has accepted her admissible terminal dues without prejudice to her rights and contentions. Stop paragraph. The issue in question. No, the validity of the impugned order has to be decided upon exchange of affidavits. Stop. Let affidavit in opposition be prepared and circulated within a period of 6 weeks. Reply, if any, within a fortnight thereafter. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period.
May I file the affidavit service?
Please.
তখনই তখনই ও দিচ্ছিল তখন তখন এটা এটা ফেয়ার করে লিখে দিয়েছে ফেয়ার করে লিখে দিয়েছে হ্যাঁ এত ভিড় ছিল না মানে ওই অবধি তো ভিড় একটু করে নিন না রাস্তাতে যা সাহেব বলে সব দিয়ে দিন হ্যান্ড ওভার করে দিন একটু কাইন্ডলি নিন হ্যাঁ হ্যাঁ ঠিক কথা স্যারকে এনাকি স্যারকে বলা ছিল স্যার কি বলেছিল না তৈরি অনেক করে তো জজ সাহেব বসে গেছে তো মামলা রাখ শুরু হয়ে গেছে একটা হিয়ারিং ম্যাটার আছে হ্যাঁ ওটা দেখুন যদি হয়তো জজ সাহেব যদি অনুমতি দেন তো হবে আরে মেনশন আমি ছিলাম তো গড়া থেকে ছিলাম শুধু তো একজনের শুনলেন বাকি সব জমা দিতে বললেন লেখাটা খুব টেরা বেঁকা আজে বাজে ছিল আমি ভালো করে ফ্রেশ করে লিখে আসো ততক্ষণ তো মামলা শুরু হয়ে গেছে আচ্ছা সেটা ঠিক বলেছেন না মানে হ্যাঁ আবার খুঁজতে হবে তো না এটা এখন আমাদের মেনশনে কি নেমে গেছে লিস্ট যেরকম দেওয়া আছে 1 2 3 4 করে দিতে হবে অনেকেই তা দিচ্ছে না তো ওইটা করে নিয়ে এসছো ঠিক আছে এটা একটু নিয়ে নিন না এটা তো কোনো ক্ষতি নেই এটা ওই কেউ হাত পা বাঁধেনি আমরাই তো রয়েছি আপনাদের সঙ্গে আমরাই তো সঙ্গে রয়েছি আপনাদের বার অ্যান্ড বেঞ্চ মিলেই তো হচ্ছে এসো স্যার স্যার শুনছেন বলছি এটা তো রোজ রোজ হবে না আপনি বলবেন যদি 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 এটা ফ্রেশ করে নিয়ে এসেছি যদি এটা না নেয় তো বাদ দিয়ে দেবেন এটা ফ্রেশ করে নিয়ে এসেছি একটু 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 কাইন্ডলি ঢুকিয়ে দিন প্লিজ আপনি তো হেল্প করেন আমি জানি তো হিয়ারিং মানে আগে মান্থলি লিস্ট রান করছি ইনক্লুশন হিয়ারিং এর জন্য হ্যাঁ সব দিকে তোলা লেখা আছে সমস্ত টোটাল লেখা আছে করে দেবো লেখা আছে এই সব লেখা আছে এই দেখুন লেখা আছে এই যে স্যার দি ম্যাটার ওয়াজ রানিং ইন সিরিয়াল নম্বর এত হ্যাঁ একদম আন্ডার হিয়ারিংটা আপনার ক্যাপিটাল অক্ষর লিখে দেওয়া হয়েছে ঠিক আছে ঠিক আছে স্যার না সো কাইন্ড অফ বলে যেতে হবে স্যারকে বলে দিয়ে যাবে একটু ব্যাপারটা ছিল তখনও স্যার এত ভিড় ছিল না যখন এই যে যখন এত ভিড় ছিল হ্যাঁ আপনি একটু পার্সোনালি দেখে ঢুকিয়ে দেবেন হ্যাঁ
পানিশমেন্ট তাহলে কি আমরা লিড নিয়ে দেবো যে একে ফার্দার রিপ্রেজেন্টেশন করার পানিশমেন্ট না আমাদের এটা after filing this petition they have now that we have they cannot exempt penalty imposed under section I humble prayer I get see ये हो गया practically
মানে 18তেই আছে টিফিন করছে দাদা কোথায় রে? মেসেজও পৌঁছে গেছে? জানি তো কথা বলেছি মা কোথায়? মনের সাথে সবকিছুর একটা সম্পর্ক আছে।
এদিকে বসে, এদিকে বসে।
There's been filed in earlier alleging. Currently alleging violation of the solemn direction passed by the bench. In a public interest litigation. WPA with bracket P number T26 of 2023. Order dated of solemn direction বলেছি তো solemn direction dated code solemn direction dated 11/7/2023 Please note that see the order dated 11/7/2023 So please note that the relevant portion, the relevant portion of said order dated is quoted herein. So phone portion ঠিক আছে বলে একদম 2 থেকে প্যারাগ্রাফ 2 এই দুই কথাটা লেখাও থাকবে প্যারাগ্রাফ 2 থেকে শুরু করে প্যারাগ্রাফ 9 অবধি next please note that Ram from copy of the contempt application was duly served upon you. But unfortunately, till date, there is no representation before the division bench in the contempt proceeding on your behalf. But unfortunately, till that there is no representation on your behalf before the honorable division bench in the contempt proceeding.
take note of. Let's say contempt proceeding. The contender numbers 1 and 2. I dot E dot. That is a I dot E. Pradhan and the secretary of concerned Gram Panchayat is filed, have filed some documents inter alia claiming that to meet up the demands of the repetition, claiming that to meet up the demands of the petitioners stroke villagers. And a scheme has been adopted by the Kampunchi of 1 kilometer for construction of concrete road cover
Madam, for the petitioner, Madam, I'm sorry, Madam, with folded hand, Madam, I'm praying apology, Madam. I was, Madam, struck off, Madam.
No, it's all
Two
right.
matters, Madam. I'm sorry, Madam.
Yes, yes.
Madam, the petitioner before your lordship, Madam, praying for the compassionate appointment. Madam, the petitioner was appointed, Madam, the petitioner number one, the father, Madam, he was
How
appointed.
many years service left?
Madam,
How many years service left?
Madam, I tell you, no, he was retired. Malad, I tell your lordship, 1991, he was appointed as Malad Group D.
I have checked up your entire petition.
Malad.
How many years service left on the day you were voluntarily retired?
No, I was
compulsorily retired
Malad,
on medical grounds.
Yes, I was forced to retire on the medical ground in the year 2021. Malad, retirement due on Malad 2023.
Right.
Malad,
So you didn't have 2 years of service left.
Malad, yes. Malad, the rule says Malad within 2 years, Malad incapacitation, Malad 2 years I have to apply for. Malad, I have applied within 2 years.
No, you are required to have 2 years of service left.
Yes, service left. Malad service, Malad I was about to retire Malad 2023. Malad I made an application Malad December 2020. Malad 21, I was Malad compelled to retire without Malad even Malad sent me to Malad the medically Malad incapacitation. Malad the medical board also Malad said I am unfit to work. Malad they Malad since I was forced to retire on the medical ground, Malad they are now treating my retirement Malad 2021.
You got your salary? It's not that you didn't get your salary?
No, Malad the
what? No,
the petition is Malad before your lordship today.
Yes.
The petitioner number 2, son Malad of the employee.
Show that you are entitled. Where is your entitlement? Your date of retirement will be 21. Your regular or the normal age of superannuation is 23. You didn't have 2 years of service left. How will the compassion appointment be given to you?
Malad, your lordship kindly come to Malad once P4 Malad page 20, Malad 22. Malad, your lordship kindly consider this Malad date. Malad, before that, I'm sorry, Malad P1 page Malad 18. Malad, this is the Malad first application.
No use going to that because you have been paid your salary.
No, Malad, I had no control over there, Malad, whether I was, Malad.
You want your retirement date to be preponed so that you get more than 2 years of service left so that your son can get the compassionate appointment?
No, Malad, your lordship, Malad, the circular says, Malad, I have annexed, Malad, circular says, Malad, 2013 circular, Malad, I have to apply within 2 years from Malad before Malad retirement. Malad, my retirement date was Malad due to retirement 23. Malad, I applied for January Malad 2021. So therefore, Malad, before 2 years, Malad, the medical board found I am Malad not fit for the work. Malad, I was forced to retire Malad on 2021 October 2000 from 1st November 2021. So therefore, my lord, Malad, considering my application, Malad, within 2 years, Malad, I didn't know, Malad, when I applied for in 2021, 1st January 2021, that my father would be retired or Malad will be Malad, forced to retire in the Malad month of October or on and from Malad 1st November 2021. So Malad, I had no control over the Malad, the authority, or Malad didn't had the knowledge that my father would have Malad would retire Malad November 21. So Malad, the application when this Malad, the application was made within 2 years. Malad, your lordship kindly
please come. I followed it.
Malad, your lordship kindly consider this Malad circular once. Malad, kindly, your lordship kindly. Malad, I am also annexed in Malad, your lordship.
You annexed it?
Yes, yes.
Then you hand it
yes,
first. Wait, which page?
Malad, your lordship.
Which page, Feruddin? Which page?
My lord, kindly come to page 25.
Yes.
My lord, first your lordship kindly consider, my lord, this, my lord, notification, this, my lord, compassionate appointment 2013, this will come into force with the effect from the date of issue. My lord, then, my lord, application. My lord, this shall apply to the dependent family member of a government employee who, my lord, I counts, my lord, B, to B, is disabled permanently or otherwise incapacitated, rendering him unfit to continue in service prematurely on being declared permanently incapacitated by the medical board found by the government. My lord, I applied, my lord, long prior. Then, my lord, the next page, your lordship kindly eligibility. 6. My lord, eligibility. Who can apply? My lord, your lordship kindly turn over. My lord, I fall, my lord, 6B. My lord, the next page. My lord, kindly, my lord, consider in case of premature retirement and concerned employee had at least 2 years service left to reach the normal age of superannuation. My lord, kindly, my lord, mark normal, my lord, my point, my case, my lord, I am banking upon this, my lord, particular. My lord, I was normal age of superannuation 23. So I made the application within 2 years. My lord, this is my case. My lord, that was not considered.
Very well. The petitioner number 1 was employed in the judgeship of Howrah. Stop. Due to his ill health, he applied for premature retirement on the ground of medical incapacitation. Stop. The prayer of the petitioner for premature retirement was accepted, and on consideration of the report of the medical board, the service of the petitioner stood the petitioner stood retired. The petitioner stood retired prematurely from service on 1st November 2021. Stop. An application was made by the petitioner number 2, his son, seeking appointment on compassionate ground, relying on the West Bengal Scheme for Compassionate Appointment, 2013. Stop. Under the said scheme, if a government employee is disabled permanently or otherwise incapacitated, rendering him unfit to continue in service, prematurely on being declared permanently incapacitated by a medical board formed by the government. কি দিয়ে শুরু করলাম? ঠিক আছে. There is a scope for compassionate appointment, as the petitioner number 1 was declared permanently incapacitated by the board. Accordingly, prayer has been made for providing appointment to him. Appointment to the petitioner number 2. ঠিক আছে? The eligibility for being considered for appointment in case of premature retirement lays down that the concerned employee had to have at least 2 years of service left to reach the normal age of superannuation. Stop. The normal age of superannuation of the petitioner number 1 was 31st July 2023. Stop. Paragraph. As the petitioner number 1 was left with less than 2 years of service tenure. On the date, he was declared permanently incapacitated, accordingly, his prayer for compassionate appointment of the petitioner number 2 has been rejected. Stop. The petitioner is aggrieved by the same. Stop paragraph.
Other aggrieved, my lord, I applied for the medical board, my lord, applied, my lord, when
It has been submitted that the date of making the application seeking voluntary retirement on account of medical incapacitation was made long prior to the 2 years of his superannuation. Stop. The petitioner number 1 did not have any scope to ascertain as to when the medical board would be constituted. Stop. The date of application of the petitioner seeking premature retirement ought to be the date which has to be taken into consideration for applying the said scheme for consideration of the prayer for compassionate appointment. Next. The court is unable to accept the contention of the petitioner as regards the 2 years of service required. 2 years of service period left. Period left prior to superannuation for consideration of the case on case for compassionate appointment. Stop paragraph. The date of the application seeking voluntary retirement is not the reckonable date in terms of the scheme. Stop. The date on which the employee is declared medically incapacitated is the actual date which has to be taken into consideration to ascertain as to whether 2 years of service period was left for the employee. Stop. In the instant case, even though application was made more than 2 years before retirement, but the petitioner was actually retired prematurely only on and from 1st November 2021. Stop. Prior to that, the petitioner number 1 received his regular pay. Stop paragraph. As the petitioner admittedly, petitioner number 1 admittedly did not have, the petitioner admittedly had less than 2 years of service tenure left. On the day he was declared prematurely retired. Accordingly, his prayer for providing compassionate appointment to his son, petitioner number 2, cannot be accepted. Writ petition fails and is hereby dismissed.
Grateful.
Service is taken on record. Next.
Grateful.
Lordship, in this matter, Ms.
Wait,
Kamala
please,
also
Lordship.
the appearing on behalf of the State Fisheries Development Corporation, my lord. She could not appear to due to some personal difficulty, my lord. I am praying for only not today. Keep it on tomorrow, my lord.
But the only point which was decided by your lordships, my lord, lordships were pleased to, my lord, prima facie convince, my lord, that if a resignation is accepted, my lord, and my lord, rules is there, my lord, that it has to be accepted within 1 month, giving 1 month's notice, my lord.
Lordship,
My lord,
keep it on
whether
tomorrow, my
before, my lord, that, my lord, acceptance, my lord, whether an employee can apply for, my lord, withdrawal or, my lord, cancellation of that resignation or not. First thing. Second thing, my lord, even after, my lord, when within the 3 months elapsed, my lord, the notice of 1 month lapsed, my lord, nothing was received from the communication, no communication was received from the employer. Then rather, thereafter, after lapse of 3 months.
You got the judgments?
Yes, yes, my lord.
Lordship, keep it on tomorrow, Lordship.
Lord, tomorrow.
Supreme Court judgment?
Yes, my lord. Supreme Court judgment.
In which matter?
My lord, so far as the retirement is concerned, my lord, my lord, resignation is concerned.
Resignation, yes. What is
12, my lord, 12 judgment is there, my lord, it follows, my lord. In so many judgments have been followed in, my lord, earlier judgments also followed.
give the cost title once?
My lord, that is, my lord, Dr. Mrs. Suman versus B. Join versus Marwadi, through its secretary and others.
All right. Yes.
And other judgments also,
Tomorrow?
Supreme Court, my lord, that was reliable. My lord, instead of tomorrow, my lord,
Day after?
my lord, on Thursday, my lord, because 2-3 matters, my lord, NIA matters that specially fixed, my lord, I have to attend that, my lord. Only difficulty, my lord. I'm ready today, my lord.
I'll take it on Friday.
Friday, my lord.
Lordship.
My lord.
List niche Friday.
Deep lord.
Great.
What did I am for the petition?
Man, for the state response.
As per your lordship's reaction, Malad, I am as profession, Malad, serve the notice to statement.
Notice? No, your other side is here.
Well, the petitioner is an auxiliary fire person service candidate, Malad. As per when they are denied the candidature, Malad, they move before your lordship. As per your lordship's direction, Malad, they give a reasoned order, Malad, page 37. And
Yes,
Malad,
that the challenge.
Malad, page 38, not Malad, that was not challenge. Page 38 is the relevant portion of the reasoned order. 38 of the writ petition.
38.
38, ma'am.
Yes.
May I read, my lord?
1 minute. Yes.
Page 38.
Yes.
Therefore, through the process of engagement has been completed, considering the observation of the Honorable High Court that as the petitioner was within the prescribed page limit on January 1st, 2017, the petitioner ought to have been debarred from participating in the screening test, and the government order stipulates for endurance test. Apart from the qualification, it is ordered that the special endurance shall be conducted in the district of Paschim Midnapur, where the instant application will be allowed to the participant. The endurance test shall be similar to the endurance test when the district of engagement of auxiliary fire operators. On being successful, the applicant will be considered for engagement as auxiliary fire operator, but if the applicant failed to secure the qualifying marks and or marks obtained by the last engaged candidate in the district, he will not be considered for the engagement. Thus, this shall not be. This is the order. Thereafter, my lord, they are waiting for the 34 months. Nothing. They are sitting.
They are waiting for?
The authority is sitting tight for 34 months. They are not taking the test.
Not taking the test?
Test. Thereafter, my lord, in 2022, petitioner filed another writ application. During that writ application, my lord, they are during one order passed by the coordinated bench, my lord, and they are saying that you are not qualified. No,
not qualified.
No opposition, nothing was filed. Nothing. In the writ petition order, my lord, page 39.
Page 39, I can see endurance test was held on January 23.
After filing of this writ application,
the petitioner was found to be disqualified.
Disqualified, man. But no, why
not able to complete running with the qualifying time.
Yes, my lord.
Then what is to be done?
Now, my lord, we are filing an RTA application.
Yes.
In the RTA application, it is found that the petitioner get 30 marks and the lower marks is 26. And my lord, they are, when they consider the representation, my lord, page 38, petitioner will be qualified if it is found that he getting more marks than the last category person. And when we are getting the last, my lord, the tabulation sheet, in the remarks, my lord, only 30 marks. Nothing, he's failed, nothing was there.
You have the report?
Yes, madam. Only one, my lord, classification of, my lord, marks. This notification, my lord.
Page 43.
My lord, the first column, my lord, running with D host 80 meter qualifying time, my lord. Within 14 seconds, my lord.
Running with D host, yes.
80 meter qualifying time within 14 seconds, my lord.
Yes.
There is no marks with regard to that. Either you qualify or disqualify, my lord. Then, my lord, the next column, my lord, long jump, full marks 10. Remember the ladder climbing, full marks 10. Height, full marks 10. Educational.
First, he has to qualify, he has to come within the 14
Yes, my
second.
lord. Yes, my lord.
He could not come.
No, my lord.
So the next doesn't come at all.
Though he secured higher
More
marks,
marks.
but yes, ma'am. But it will only calculate.
And 34 months they are sitting tight.
We have informed, my lord. The order is here, my lord.
No.
21st March 2023.
This is the issue, Malal. He is getting more marks, Malal.
No, but then prior to that,
Malal, 14 points.
14 seconds with 14 seconds, you have to run with
within
the
14 seconds, my lord.
You did not.
14.92 seconds, my
So
lord.
that means
And
you're out.
others, my
Please
lord.
come. Please come. The matter relates to appointment in the post of auxiliary fire operator. Stop.
But in their, my lord, in their order, my lord, they are written that he getting the more marks than the last degree marks, but it is not
being successful.
More marks is this next step. That is step 2. You failed in step 1.
This is total category of physical test.
Acha. The petitioner was directed to appear in an endurance test which was held in January 2023 and he was found to be disqualified. Stop. The learned advocate for the petitioner submits that the petitioner secured more marks than the last impaneled candidate. And as per the order of the court, he ought to be given appointment if he secured more marks than the last impaneled candidate, last engaged candidate in the district. Stop paragraph. Learned advocate representing the state respondents has produced before this court the result of the endurance test. So it appears therefrom that the petitioner failed to complete the run with D. hose within bracket 80 meters within 14 seconds. Stop. In the other categories where the petitioner was assessed, he may have secured more marks than the last engaged candidate. But as he failed to complete the run within the qualifying time period, the rest of the marks obtained by him will not make him eligible for appointment. Stop. The respondent authorities have fixed the manner of endurance test of a candidate to be engaged as auxiliary fire operator. Stop. If the candidate is unable to run within the qualifying time period, he is considered to be ineligible for selection of selection. Stop. Paragraph. As the petitioner failed to complete the run within the prescribed qualifying time period of 14 seconds, he has rightly not been engaged. Stop. The petitioner completed the run within 14.29.
9 seconds.
14.9 seconds. Accordingly, the writ petition fails and is hereby dismissed.
Grateful, man.
This will be written with the records. Next.
15, my lord, I'm applying for the state respondent
And I am filing the supplementary affidavit of the report on behalf report
Crime for the
of,
petition.
in form of affidavit, which has been filed by the state respondent. My last
If
occasion.
your lordship kindly takes up the last order, wherein a direction was passed by this honorable court upon the state respondents to file their supplementary affidavit, which was not handed over to us within time. Now they have handed over to us today. In view of the supplementary affidavit that was handed over on the prior occasion, we are filing an exception to it.
They have already handed over to
Only I'm praying today, my lord, for your lordship, since they have handed over supplementary affidavit, kindly takes up the matter tomorrow. I'll just go through it. If it is in
How could you prepare the exception?
because this supplementary
Filed earlier,
affidavit
my lord.
on the last occasion that was handed over to us in presence of the court, my lord, before the court, my lord. And
The last occasion.
yes, my lord, before the
That was
coordinate bench.
September 25.
Yes, my lord, before the
And this is the exception.
yes.
What
Now,
else do you want to prepare?
now previously they had handed over to us
One.
where one page was missing. So we had
But 10 was missing,
missing.
my lord. That is why, my lord.
Tell me one thing. What is your prayer?
Well, my prayer is compulsion appointment on land loser scheme.
Land losers.
Now I was employed.
All right.
Subsequently, I was terminated.
Yes.
Now, my other brother has been employed. Now, we are only saying that if you have employed, we have terminated me, and you have employed my other brothers whose land was not acquired. It was my land who was acquired.
The land stood in your name?
Yes, my lord.
Then how has employment
Yes,
been given to the other brother?
I was working since 2012 to 2017.
Show me your order of termination.
Let me come back, my lord. In this matter, my lord, Mr. Amit Gupta is appearing, my lord, leading me, my lord.
You must be prepared.
My lord, let me come back, my
At the
lord.
same time, my lord, I am also praying an adjournment
me come
today
back.
because she has handed over to me the supplementary.
They have
petition.
also
I'll
handed
just
over the
go through it
exception,
and
my
come
lord.
back tomorrow. Kindly, my lord.
Let me come back, my lord.
It will not take much time, my lord, tomorrow.
Supplementary affidavit on behalf of the respondent number 9.
Amit Kumar Gupta দিয়েছিস নাম দিয়েছিস?
And is this exception to the supplementary?
No.
No.
This
to the-
exception is the
yes,
prior one.
Yes.
Is taken on record. Stop. Exception filed by the petitioners to the report of the state respondents. We also retain with the records. Stop. By consent of the parties, release the matter for further consideration next Monday.
Grateful, madam.
Plan for the petitions. On previous occasion, nobody appeared for state. My lord was pleased to direct us to serve notice upon the state.
Who is appearing?
The senior advocate, Mr. Bimalendu Chakraborty, he has expired.
All right.
I am served the notice upon the learned junior advocate, Mr. Krishno Kesapal. He has received the notice.
Where is he? Phone number given? Phone number, did you take the phone number?
Number is there.
Did you call?
Now,
Tell your junior to call and just submit what the matter is about.
well, petitioners are the contractual employees. Sometimes in 2019, 2020, they were engaged as pharmacists in different correctional homes.
Hmm.
In 20, they are getting a paltry amount towards the remuneration. In 2024, government, on the last annexure, page 45, government enacted a circular enhancing the pay benefits of the contractual employees. We are entitled to that. That was
9008.
Page 45.
This is 24.
Yes.
There are previous circulars. You are relying upon this.
This is the latest circular.
Did you get it in the previous one?
No, nothing.
Then,
This is
when were you engaged?
2019, 2020. 2019, 2020.
1920.
Group
See page 45.
45.
Page 45 you are relying upon.
Yes.
Page 45 mentions about 9008.
That is the
Parent one.
Parent one.
Parent one is applicable only to employees who have worked for 10 years or more. You have not worked for 10 years.
Kindly come to group C, column number group C.
Yes.
The second period of engagement, left hand side has mentioned. The second column, on completion of 5 years from initial engagement.
Yes.
The remuneration has been fixed 21,000. I'm on that.
Whether this is at all, you are serving where?
Different correctional homes.
Correctional
in
home.
different districts.
As contractual pharmacists in different correctional homes. Whether this will be applicable in your case?
And now, my lord, it was heard by coordinate benches on different occasions. Report was called for from the state authority.
That has not been.
Yes, report
They have
was
filed.
filed. They came back with the report. Report is in the file.
What is the stand?
They stand that they took point that in view of the circular of 2011, these petitioners were not employed.
Petitioners were not
employed in with regard to in respect of that circular they have referred. That is there.
Even before looking at the report, I told that this will be the stand.
But I am on the second column, my lord. Group C, second column.
No, but then if you are not entitled to the parent one, how will you be entitled to get it by the subsequent one?
Well, page 4 of the report, it is in the file, my lord. Report take to the
Yes, yes. Yes, I have it.
Paragraph 8, they have mentioned.
They have placed it. I don't think you'll get the benefit. Please come. The petitioners are working as contractual pharmacists in different correctional homes in the state of West Bengal. Stop. They seek benefit in terms of memorandum number 1091-CAPSF within bracket P2 dated 1st March 2024, published by the Additional Chief Secretary to the Government of West Bengal, Finance within bracket Audit Department. Stop. The memo relied upon by the petitioners relates to the enhancement of remuneration of casual/contractual workers engaged in various government establishments in terms of memo number 9008-F within bracket caps P dated 16th of September 2011. Stop. The petitioners were engaged in the year 2019-20. Stop. Achha. The subject memo relying on which the petitioners seek the relief mentions about the casual/contractual workers engaged in various government establishments in terms of memo dated 16th of September 2011. Stop. Admittedly, the petitioners were not in service when the 2011 memo was issued. Stop. The Special Officer, Directorate of Correctional Services has filed a report denying the claim of the petitioners. Stop. It has been mentioned that as the petitioners were not entitled, not eligible to avail benefits in terms of the memo of 2011, accordingly, the memo relied upon by the petitioner cannot be accordingly benefit in terms of the memo relied upon by the petitioner cannot be allowed. Stop. The court is of the view that as the petitioner was not covered by, not eligible for enhancement of remuneration in terms of the parent memo of the year 2011, accordingly any benefit in furtherance to the parent memo cannot be made applicable to the petitioners. Stop. Next. The submission of the petitioners that there is a provision for enhancement of remuneration on completion of 5 years of initial engagement will not come to his aid, as the said 5 years from initial engagement has to be taken into consideration in terms of the memo of the year 2011 and not in terms of the subsequent memo relied upon by the petitioner. Stop. In view of the above, no relief can be granted to the petitioners in the instant case. The writ petition fails and is hereby dismissed. Next. None for the state. Are you there for the state?
Yes, madam, I have missed the matter, madam, kind of being apology.
দিয়ে দিন নাম।
I am for the Union of India.
Yes,
I can 17 appear for the petitioner, my lord. In this
matter, Lordship, for Indian Museum, Lordship, Mr. Orjit Bokshi is appearing. Lordship, he is actually, Lordship, contesting for this ensuing election, legislative assembly election, Lordship. If Lordship may kindly keep it after 4th May, Lordship.
Why will the petitioner suffer?
My lord, the
only
thing is, my lord, since my learned friend is seeking an adjournment, my lord, there's a pending deduction for submission of a report by the director of Indian Museum.
Prepare the report.
Lordship, that
report to be filed by the director of Indian Museum.
Yes, who is going to prepare that? Learned advocate.
It's pending since 24, my lord, August.
Yes, but the learned advocate is right now not available.
Lordship, I shall communicate, Lordship. I shall communicate because I also do the Indian Museum matter, Lordship. I shall communicate, Lordship, so that I will try to prepare the report in the meantime, Lordship, so that if he return, if he join the bar, Lordship, Lordship, if join the bar, Lordship, then, he can submit the report. Kindly accommodate. It's a long matter, Lordship. They waited for this long period.
Accommodation has been sought for on behalf of the learned advocate representing the Indian Museum. Stop. The report directed to be filed by the museum has not been filed till date. Stop. Let the report be prepared and circulated. Stop. Released 11th of May.
Grateful, Lordship.
Grateful, man.
I'm for the respondent.
On the last occasion, the Honorable Court was pleased to direct them to medically examine the petitioner, but they have not.
Not examined?
Last 2 occasions, they have not.
Lordship, the board was constituted on.
The microphone is there.
Lordship, on December 2024, board was constituted and the petitioner re-checked and the report was submitted before Registrar General, Lordship, by the department, Lordship, as per my knowledge, Lordship.
By the before the Archie. হ্যাঁ এটা খুলে দিন আচ্ছা দাঁড়ান ছিঁড়ে গেছে ছেঁড়া The report says that though you are physically fit, but you are mentally unfit to handle duties with arms and ammunition, especially in stressful situations.
But the other hospitals say otherwise.
Other hospital report will not do. This has been done in terms of the court's order. So the court will abide by whatever has been given by them.
The thing is that kindly have a look at their own findings. They only interviewed me. No medical checkup was done.
No.
Kindly have a look at the last.
Sir, I can see conduct of fresh medical examination. The board was present. Please come.
Ma'am, kindly have a look at
Peruse the
last order
report
dated 20th
of the medical board.
20th November.
After that, medical
submitted in a sealed cover before the Registrar General of this court. Stop. It appears therefrom that the Board of Officers assembled at the Composite Hospital BSF Kolkata as per the direction of the Honorable High Court. Stop. As per the direction of the actor. The petitioner was admitted in the hospital for observation of his physical and mental health condition. He underwent relevant medical checkup for investigation. CT scan of the brain, 2D-echo, EEG, and other blood tests were conducted. Stop. The opinion of the cardiologist, neurologist, and the psychiatrist was taken. Stop. The board opined that though the petitioner is physically fit, but he is mentally unfit to handle duties with arms/ammunition, especially in stressful situations. Stop. Paragraph. On considering the medical report forwarded by the respondent authority, the court is unable to accept the petitioner's prayer for engagement. Stop. The petitioner is mentally unfit to be engaged in CAPFs. Stop. The writ petition fails and is hereby dismissed.
Let a copy of the.
You want a copy of the report?
My lord, yes. And one more indulgence.
Yes.
Lord, he has been retired by them medically. So all the pension.
Oh, this is not your for engagement. This was your retirement.
Retirement.
Yes.
Totally engagement hobe na. Where is the impugned order?
My lord, can we have a look?
Achha, let a copy of the eta diye din to. Let a copy of the medical report be handed over to the learned advocate for the petitioner. Stop. Achha, from the documents already forwarded by the respondent authorities, I see there are more than one copy. All right. So one will be given to the petitioner. All right.
I will communicate to the department.
Yes. এখানে দেখুন তো দুটো কপি রাখা রয়েছে মনে হচ্ছে these are the same একটু দেখে নেবেন আমার মনে তো হচ্ছে same 6th of December 6th of December 6th of December signature 6/12 possibly these two are same. Keep one page 30 and 31 keep one and give one to the petitioner. ঠিক আছে একটা মিনিট যেখানে বললাম এনগেজমেন্ট সেটা এনগেজমেন্ট হবে না what was under challenge
Lord, page 16.
page 16
It is in Hindi, my lord.
ah
It says that I am 43% handicapped.
how much
43%.
43%,
Oh,
Lordship.
43%.
Generalized anxiety
General-
disorder with panic disorder.
And
And
this,
principal eczema.
this is curable, my lord. This is generalized anxiety disorder with panic disorder and this is mental angina.
At this moment, Lordship, it's very difficult to
This is very
decide
light
the department, Lordship.
kind of ailment.
আচ্ছা কি বলে তাহলে আপনি লিখবেন the court is not inclined to interfere in the matter interfere with the order of retirement of the petitioner on the ground of physical unfitness ঠিক আছে এনগেজমেন্টটা থাকবে না and as the petitioner has already retired from service comma let his terminal dues be disbursed without any further delay
Well,
all
he
right
is medically retired.
medically retired
Yes.
yes
Can I add that part?
yes medically retired all right
But-
what is the can for
This is during the pendency of the petitioner, he was medically retired.
oh acha can disposed
Much older.
obliged next
And item 19, Malay appearing for the petitioner in this matter.
Malala.
Release have been
Respondent
completed.
number 1.
there was
Reply.
an order Malala, previously by the report
Reply.
give
Reply.
Dekhi.
Original reply.
Copy served
Yes, yes.
Yes. Well, copy served, Malay, everything is done, Malay. Copy served.
all right
Copy service করেছিল ওদিন
reply
আচ্ছা reply very good reply ঠিক this is a case matter wherein the petitioner was a navy officer not below the commission rank he got employed in PNB now the only dispute is in respect to the pay fixation whether the
pay
protection has been given to me yes now Lordship will kindly takes my appointment letter page 33
yes
Lordship will kindly takes this is a 5th February 2015 document. Now Lordship will kindly sees appointment in the clerical cadre of the bank. You will draw salary per month in the scale of pay applicable to clerical employees in the bank, which is 7,200 band. This was the band. Now Lordship will kindly takes salary receipt here. No.
yes
Yes, the salary slip last drawn from the page 54 onwards, Lordship will kindly takes. Yes, Lordship will kindly takes salary is basic salary 7,200. So I was getting only 7,200. That was the basic salary. Now my lord, maybe salary to slip double check. Yes. Now Lordship will
conveyance allowance
no.
Dearness.
Lordship will kindly comes to page 99.
99
Yes.
yes
Yes, this was my last salary slip, which I obtained from Indian Navy. Pay in band 10,550, grade pay 2,800. Total is 13,350. My pay protection was not given.
Were you entitled to pay protection?
Yes. Because I have retired as a below commissioned officer. So that in that case there is no dispute. Even they have also admitted that. They are taking a point that they have what they have what has happened. I have annexed a chart. Lordship will kindly take the chart at page 64. Now notification I'll come. I'll come. Before that, I'll just
page 64
yes. Lordship will kindly say page 64 the chart. Well, clerks past is 7,200.
Yes, basic.
7,200.
Huh?
Now, my lord, as per the notification, if I am entitled to the pay protection, but that would have been my lord, 13 column, 13,700. After that, my lord, when my lord, this fourth my lord, revision came, then my lord, my salary would have ought to have been my lord, 22,385.
No, if your basic change, all
Naturally, yes.
changes.
Now, my lord, I was getting a pension from the my lord, Navy, and I was also getting my lord, DA.
Mm.
Now, one fine morning, my lord, they have my lord, what they have done, my lord, without hearing me, without giving us a reasonable opportunity to at least my lord, plead my case, my lord, they stopped. Even my lord, they
what?
my Dearness allowance. I was getting
stopped
the PNB.
All right.
Because well, what has happened, well, the pension used to also come into the PNB, and I am also the employee of the PNB. So both ways, well, I was trapped. Now, well, what they have done, well, they have stopped my DA. I was getting the pension only. They have stopped my DA on the basis that already, well, you have given the, and also, well, 56,000 recovered from my salary. So, well, this was the well, arbitrary, well, whatever the action they have done. Now, Mala, I am on a basic yes. Now, Mala, Lordship will kindly seize, Mala, page 83. The notification, Mala, Lordship will kindly takes, Mala. Mala, first one is 79. After that, Mala, 83, Mala, 81.
Which one to look into?
Mala, 81 is the latest, Mala, 2018.
81.
Yes. Clarification, yes. So, Mala, 81, Lordship will kindly takes. Yes. Mala, first year, Lordship will kindly says 82. Mala, however, 3, paragraph 3. 3.1. Insofar as re-employed pensioners are concerned, the entire pension admissible is to be ignored at present only in case of those civilian pensioners who held post below Group A and those ex-servicemen who held post below the ranks of commissioned officers at the time of their retirement. I was not a commissioned officer. Their pay on re-employment is to be fixed at the minimum of the pay scale of the post, that was I was showing before Lordship Malone, in which they are re-employed. Such pensioners will consequently be entitled to Dearness relief on their pension. For this purpose, the central government departments concerned, including subordinate organizations, state government, corporation, companies, so and so, employing central government pensioners shall be required to issue certificate indicating the re-employed pensioners retired from a civil or military post in central government and was holding a post not included in classified as Group A or post below the rank of the commissioned officer in armed forces. The entire amount of pension sanctioned by the central government was ignored in fixation of the pay on re-employment. That is, no part of the pension was taken into account in such fixation of pay in the pay scale of the post in which the central government retiree was re-employed. Then Mala Lordship will kindly takes B. In the cases where PBOR below commissioned officer retired before attaining the age of 55 years, this is my case, and re-employed thereafter, and their pay fixed at a higher stage because of advance increments and no protection of the last pay drawn were given. The pay should be treated as fixed at a minimum for the purpose of ignoring the entire pension and allowing Dearness relief on pension. So, Mala, even if they have given me some Mala benefits in respect to whatever the Mala division of pay, then also I am entitled to the Dearness allowance. For benefit of advance increments, the policy for the same should exist in the re-employing department, and a copy of such policy matter should be enclosed with the required certificate, but not issued in my case. But after granting benefit of advance increments, the last pay drawn by the pensioners is protected. The pensioner in such case will not be entitled for Dearness relief on pension. Now, Mala, the illustration has been given, if your lordship allows me to Mala, place it, Mala. A military pensioner was drawing the pay of rupees 6,300 in the pay scale of 5700-140-8290 from 1st July 2002 and retired from service on 31st October 2002 before attaining the age of 55 years. He was granted a military pension of rupees 3165. He was re-employed in a civil post on 1st December 2003 in the pay scale of 5,000, 150, 8,000. The post which the pensioner held in the army before retirement is non-commission post. If his pay is fixed for 5,600 after granting 4 advance increments in re-employed post, then he will be entitled for dearness relief on pension, as his pay fixed for rupees 5,600 in re-employed post is less than 6,300 already drawing in the army before retirement. However, if his pay is fixed for 6,500 after granting 10 advance increments in the re-employed post, then he will not be entitled for dearness relief on pension, and his pay fixed for 6,500 in re-employed post is more than 6,330 already drawing in army before retirement means last. So, Mala, at best, my lord, when my pay was fixed, Mala, it should be 13,750. Then, Mala, as per the provisions of the whatever the division, Mala, I am entitled. Mala, what they have done, Mala, as they have not fixed, so I am entitled to dearness allowance to my pension. Now, Mala, what they did, Mala, they have not done this.
Both ways. it
Both
has been
ways.
curtailed.
Both. In today, my pay scale also, Mala, have been suffered, Mala, for last 10 years. So, Mala, this is my grievance before your lordship, Mala, and they have illegally, Mala, deducted my pension, whatever they have calculated that I have got 56,000 excess pension, and Mala, they have deducted from my salary without giving a reasonable opportunity.
All right. Now tell me, what is the stand in the report?
Yes, Mala, their report stands, Mala, lordship will kindly come, report. Yes, I don't know. Mala, they are saying, I'm bolchi. No, exception, I am not.
Report.
Your report, yes. Lordship will kindly takes, my lord. They have taken a point of at yes, well, they have taken the point that I have not. They are basically, well, they are saying paragraph 9 of the report.
Yes.
Well, I say and submit that in reply to the complaint lodged by the petitioner Samadhan portal in the official website to Punjab National Bank, the respondent bank has categorically stated the applicant is marked as PUSU observer as he is working in the respondent bank and getting DA in his pension. Furthermore, it is also to be noted that petitioner had to refund the DA from date of joining in the bank, as to different DA is not permissible for different pensioner. After that, he says from the calculation sheet of the petitioner, it appears the sum of 51,367 was paid in excess to him, and that is the petitioner who is liable to repay back the same, and this respondent back communication dated 23rd April 2018 has intimated the petitioner about the repayment system, which is that 7,500 to be deducted on a monthly basis from the petitioner with effect from May 2017. The respondent bank, while going through the said calculation, found out that there was certain miscalculation made. By rectifying the same, and in good faith and gesture informed the petitioner that rupees 3,000 is to be deducted instead of 7,500. The same would be in effect from 2017 May up to 2018. I say and submit that after that, does any action on the bank which is undertaken, and they have also taken a point. They are basically saying, does any action of the bank which is made of undertaken as per circular cannot be construed to be held wrong. They are also supporting the circular. The petitioner in this case has not challenged the veracity of the circular. Why should I challenge? The petitioner also never questioned or intended to know as to why he received a higher grade of pay since joining. After joining, it is the duty of the concerned employee to make himself aware of the prevalent rules and circulars. After that, this point.
Page 64 is the chart that you prepared.
Yes, madam.
Please come to that once again. Your last pay drawn in the Navy was 13,000.
13,000, yes, madam. That is, madam, exact amount saying, madam.
All right, something 13,000.
13,000 plus.
That means serial number 12.
Yes.
You joined here with 7,200.
200, yes.
Right. So you should be getting the pension of the earlier job.
Yes. Yes. Yes.
This they are not paying.
Not paying. So, my fixation, as per this chart, should be at column 13, that is 13,700. That should be. This is the chart of the banks. This is not my chart. This is all India. This is not my chart. 13. This is a column 13 would have been my fixation of the pay. After that, whatever the division I am entitled, Then I would have entitled to that DA.
Pension.
Yes. Pension I should get, but DA.
DA.
Yes, DA. Now, my pension, my DA, my if gone, my then I'm only getting a very meager amount of pension, and also I'm losing my service, my benefits. And today, my
Yes.
Oh,
I have to take instruction on.
Where is the exception?
কোথায় exception?
Exception to the report in form of an affidavit.
আমি ওটাই আপনার ওইটাই দিয়েছি আপনি দেখুন নতুন কিছু কেস মেক আউট করি
Have you filed an exception?
মানে অলরেডি
This
ফাইল
is not with me. This is the first time I'm getting this.
আছে কি এক্সেপশন
Whatever it is, I was not getting.
All right. Come to your report
Yes, my lord.
and say how the petitioner's pay is protected.
My lord, when he joined the bank, re-employed that is, my lord, his salary, he got a higher salary, which is at page 12, annexure P1.
He showed that he got 7,200? No?
No, this is
of my
my,
The basic salary, it's there, 7,200.
but it is total coming to 19,115.
How come? Page 54 salary for April is there?
Annexure P1 of my report, my lord, page 12.
মানে that is মানে what they are showing মানে I'll clarify মানে subject to my correction your lordship ওটাতে
Page 54 of the writ petition,
Yes.
please come.
Yes.
Salary slip for April 15. When was he re-employed?
Was re-employed
In my lord I got my lord re-employed at মানে
16/3/2015.
March 2002
Very well. So April's salary slip is there. See, the basic salary is 7,200.
May is also same. June after 10th BPS it was.
well after 10th BPS it was fifth at my lord 11,765
This is
7,200.
my lord, annexure P1 of my report, lord, takes as one.
Why don't you please come to page 54 of the writ petition? His salary slip is annexed.
একটা চার্টে কথাই বলি
আমার
Net is gross 15,856, net 14,200.
my lordship will kindly take the chart once my lord it will be entirely clear before lordship 7,200 has been given 11,765 on the basis of the revision. That is an automatic revision. I have got it.
10th BPS.
Page 54 is his salary slip, which is generated by the bank, where his basic salary is mentioned as 7,200.
But
Then
my
you
lord,
have to take this to be the figure.
But my lord, my instruction and the annexure that I have
Yes.
on record is he has been pay protected because when he joined, he was given an increment and the total salary was 19,000.
Very well. From page 12, you show what was his basic. What was his basic in page 12?
Basic pay was no 10,115.
Then
My page, my annexure.
your
Wait a minute.
first page of your opposition, the annexure.
Yes, my lord.
Where is his basic?
Basic pay, after basic pay to be fixed at the time of joining by the bank, date of joining, basic pay. That is
10,110? 115.
Yes.
And
Special pay, there are nothing. Dearness allowance 6,360, 65 or 85. Total, it comes to basic pay after release of graduation increment 21,240.
this 10,000 figure, is it after revision?
Revision, yes, ma'am. That is the point, ma'am.
Is this after revision?
Yes.
This is
Because-
when he joined back.
Page 54, have you denied that this is not your pay slip?
I have not denied that in
Then-
my report, my lord, but this is the instruction as well as this document was provided by the bank only that says that
If this is the revised amount, then that will be different, isn't it?
my lord, and more it's already migrated to Sparsh. So therefore, he has to submit as per the circular, he has to submit a certificate. He has not done that.
Did you
to be issued by the
Did you seek for these documents from him? Whether certificate is there, not there, everything, you do not deny that he is a post-retired employee. He is a pensioner, that you do not deny. The pay protection, you do not deny. The petitioner also relies on the same circular that you are relying upon. Then there cannot be two different calculations. Please see if, not if, how it can be resolved.
And the account, this, we are no more, we cannot deal with this. Sparsh has to deal with it. Union is represented. I do not know. Sparsh is a different body altogether. I have a next, that his account has migrated to Sparsh also.
That is something very technical.
Whereas
That is not the fundamental thing.
Submit the certificate.
His calculation. Yes, Union, what is your stand?
Regarding the migration of the pension, my lord.
No, regarding his pay protection.
Regarding his pay protection, my lord.
You cannot have a say because everything will be done by the employer. So you do not have a say.
Protection, I have been instructed that he had been given a higher salary.
How? You have to reconcile from the documents. From page 54 in the writ petition where his pay slip is there, and page 12 is the document that you are relying upon. The figures differ. One is the basic pay that the petitioner received prior to revision, and the other is after revision.
Yes. My lord, some time has to be given to me because of the contradicting figures.
Tell me one thing. Has the petitioner been given an opportunity of hearing prior to doing all these things?
My lord, this is a matter of 2024. So therefore, the current situation, the officers have changed. I have to.
Officers may have changed. It hardly matters.
I really.
Why don't you give the petitioner an opportunity of hearing? Let him go. Let him sit with your officers. Your officer will also be there to advise him as to what is to be done, what not to be done, what will be his pay and everything. So if it can be reconciled, because this is a matter of calculation, there is nothing much for the court to decide over here.
And only the thing is that if your lordship decides they have fixed it wrongly, that can be also done. Otherwise, that calculation can be done. But if today only my prayer is I am suffering only on the basis of this. But today my salary ought to have been 1.5 or 1.6.
Page 12 of their opposition.
Yes, yes. I'll clarify. Page 12 কি বলছে দেখো আগে। Page 12 এ বলছে yes কি বলছে yes yes sir এই যে ওয়েবসাইটে পেজ 63 টাকা এক সেকেন্ড লসু will kindly takes the chart once page 11,765 that is at page 64 that was given a revision after the fourth this is
you are not getting 11, they say it's 10,115. Where from this figure is coming? Basic pay.
Page 62 and 63, their website showing different.
Yes.
Page 62 and 63 of the repetition.
Yes, yes.
But their website is showing that my basic pay is 7,200.
Yeah, it is downloaded from the website only.
Page 62 and
Page 12 of the opposition.
Now, Loshu will kindly take very well. I'll clarify the situation.
They can say
I'll clarify. Give me 1 minute,
Page 12.
Yes, ma'am. But this is Loshu will kindly take basic pay is 19,115 given. If I can
It
follow.
is not 19, it is 10. Or is it 19? 10,000. 10 or 9, it's very illegible. Cannot read it.
Total is 21 to 40.
Yes.
So therefore.
So, Meller, it should be have been
19.
19 or 24
19, 115.
Yes, yes, 19. Yes, yes.
All right, 19.
Now, Loshu will kindly comes to the chart. When I joined, I should have been given 7,200, 13, column 13, 13,700, page 64. What they did after this revision, they ought to have been given 22,385. But they are giving only 19,115. That is at 10. 11,765 টাকা Loshu will kindly seize, my lord.
No, sorry, I didn't get it.
Yes.
You should have got serial number 13, 13,700.
If my pay is fixed at first the last pay, it should have been, my lord, 13.
Yes.
Now, what they did after May 2015, when this revision came into effect, they immediately, without fixing this 13,700, they jumped to 11,765, just 7,200, which was automatically I was getting this. Now, on the basis of that.
11,765.
65, matlab the 10th BPS, BP just second column.
You were never paid 11,000.
Yes, yes, I was paid.
Oh, 11,000 you
Yes,
were
yes,
paid.
yes. So I was showing, my lord, only the revision was given in respect to 7,200 only. Because 11,765 was the automatic revision given by the bank in 2015 May.
Then how come 19,700?
Yes. Now what they did, Mala, instead of if 7,200 was given effect, then it should have been 13,700 instead of 22,385. Well, they fixed at 19,115.
That
is
is
a
serial
10.
number 10.
Yes. So again, also I am running in loss.
My lord, I have to get into this.
This is the main problem, Mala, and this should be clarified, Mala. This is
Page
open.
64 of the writ petition.
This calculation is too difficult for me.
Not difficult, it's very easy.
It is very easy. Page 64.
Page 64.
Stage 1. 7,200 is the basic. This is what is appearing in page 54 of the writ petition, where you see 7,200.
Yes, page 54, 7.
1 minute, let her just understand. Then if she cannot understand, it will be difficult for her to reply.
Yes.
Page 54, see, basic is 7,200. You get it? Now this gets revised.
Right.
The next column, page 64, it is 11,765. Right. You go down. See serial number 13. 13,700 is the basic.
Right.
According to the petitioner, he ought to have been paid this 13,700 instead of 7,200. Serial number 1 and serial number 13. Right. You do not give him serial number 13. The revision of serial number 1 is 11,765, which he received. That means the revised amount he receives. And then what you do, you come to serial number 10. It is revised.
19,115.
This is the figure that you show it to me.
Yes.
You get it?
So he should have got?
He should have got
22,385.
22,385.
So I shall have to take instruction.
Now you followed how the calculation has been done. Please come. The petitioner was serving the Indian Navy in a non-commissioned post. Stop. After retirement, he joined the Punjab National Bank in the clerical grade. Stop. He alleges that the pay protection in terms of the circular, page 8, dated 12th April 2018, annexed at page 81 of the writ petition, has not been followed at the time of calculating his pay. It has been alleged that the dearness allowance that he is receiving from his pension has been abruptly stopped. The amount of money which was received by him has been recovered allegedly on account of excess payment made to him. Stop. The recovery has been made without giving any opportunity of hearing to the petitioner. Stop. Paragraph. According to the bank, payment has been made in terms of the circular. Stop. After hearing the parties, Pradeep, please put that inside and don't make that noise. Parties. It appears that that an opportunity of hearing ought to be given to the petitioner. so that the discrepancy in the figures relating to his pay can be reconciled. Stop. The who will be the competent authority to hear him?
That is also another difficulty.
Why the senior manager?
My lord may refer to ombudsman, my lord.
Because
No.
migrate.
Authority, my lord, as per the rules, the bank the new employer has to give a certificate to my employer. Otherwise, my lord, this will not do. So, my lord, bank is yes, under the rules you have to give. I can show you.
You have to give a certificate to whom?
82. Lord, will kindly see, my lord. Page 82, my lord.
No. It certificate.
My lord, 82, my lord, 3A, capital A.
Huh?
For this purpose, the central government departments concerned, including subordinate organizations, state government, corporation, company, body, bank, etc., employing a central government pensioner shall be required to issue of certificate indicating the following. Whatever the fixation he has to indicate. So, this was the discrepancy done by the PNB itself. It's not the fault of the previous employer. They have done it.
Yes. Who will be the competent officer in the bank?
Competent also HR.
CPPC, full form. Centralized Council Process.
Circulate for the whole.
Right.
না সার্কেলেট কিছু করতে পারবে না because this is a different person.
Manager any হবে senior manager
Respondent number 5.
I'm again 5 6 7 মধ্যে দিয়ে
Party নেই।
Can the respondent number 5 be of any help?
Respondent number 5 বলতে পারছেন না যখন
আচ্ছা, the senior manager কি বললাম?
ডেন্টাল পেশেন্টস এর মধ্যে করতে পারবে না
Respondent number 5.
Can be reconciled. Paragraph. The respondent number 5, the senior manager of the bank, ঠিক আছে, is accordingly directed to grant an opportunity of hearing to the petitioners to find out a solution to the problem that has cropped up. ঠিক আছে. The hearing shall be conducted within a period of 4 weeks from the date of communication of this order. Stop. The report, a report by the senior manager shall be placed before this court on the adjourned date. Released on 12th May.
Grateful, madam.
Grateful.
Did you file anything today? No. You have filed the report. This report will be taken on record.
The exception file করলি
Grateful.
exception file
You hand over all documents to your client so that he gets to know what the matter is about. Otherwise, he will not know.
I am also confused with this, the entire calculation.
Nick?
My lord, I am appearing for the petitioner.
Yes.
My lord, in earlier occasion, your lordship directed me to serve the notice to the respondent number 5. My lord, respondent number 5 I served. And respondent number
I am appearing for the respondent number 5.
All right.
In
Yes.
place of erstwhile lawyer, I have been newly engaged.
Did you file your wakalatnama?
Yes, the department.
All right. Yes.
My lord, here I am challenging the order passed by the district judge, that is 154. As per the order of the Honorable High Court, this order has been passed by the district judge Paschim Bardhaman. That is 154.
Yes.
And my lord, previous impugned order which I challenged, the promotional order, if your lordship come to page 70, this was the first issue which I challenged by way of writ application before this Honorable High Court. Page 70 is the impugned in the previous writ application, which is the main allegation, my lord, against the respondent number, against the district judge Paschim Bardhaman. That is page 70. My lord, I am placing page 70. My lord, this order has been issued for the promotion for the post of supervisory, that is junior serestadar. In junior serestadar, if your lordship kindly see page 76, the junior name of the junior serestadar has been published. 15 candidates' name has been published. If your lordship kindly see for a moment, page 76.
Yes.
That is from 1 to 15. My allegation against the serial number 11. That is Orpita Borua, given promotion for the post of cadre of junior Serestadar, which is, if your lordship kindly see for a moment, unreserved category. In unreserved category, Orpita Borua is the ST candidate.
All right.
ST candidate. And if your lordship kindly see for a moment, the page 44 is the draft gradation list, in which my name was appeared. Page 44 is the draft gradation list, and my lord, page 50.
Page 44 is not the draft gradation.
Yes, my lord, that is Office of the District Judge of Paschim Bardhaman English Department.
That is draft, but where is the gradation list?
My lord, that is start letter. My lord, page 50 is the.
All right.
That is the by way of order.
All
District
right.
Judge
Yes,
has been
yes,
passed.
yes.
Page 50.
Page 50. Your name is there?
Yes. Yes. Serial number 12.
You are Shrikanta Majhi.
Yes.
Serial
That is
number
schedule
12?
cast. I am schedule cast.
All right.
And 50-point roster has been maintained in this draft gradation list. But in the final gradation list, that was not maintained. But instead of my name, the district judge replaced that Orpita Borua in unreserved category, who belong to ST candidate, ST category. But this draft gradation list, page 50, Orpita Borua name is not more there. My name is there as serial number 12. And after that, my lord, if your lordship kindly see for a moment, the page 64, my date of appointment and date of appointment of Orpita Borua. Page 64, my date of appointment.
'64 is your date of appointment.
Yes.
Yes.
Serial number 14, my name is Shikanto Majhi, 10/9/2012. And my date of confirmation is 10/9/2015. And my lord, page 65, serial number 2, Orpita Borua. And his date of confirmation is later due to non-performing the qualifying test. That is page 66, your lordship get. Orpita Borua, date of appointment, same date, 10/9/2012. But date of confirmation is 10/3/2016.
Appointment date is the same.
Same.
Confirmation come later on because
due to lack of yes.
Yes, then
10/3/2016. And then the 70 is the impugned in previous writ application, and writ application has been filed. And rules I am showing before you, the rules. What is the rules? That is for the Serestadar, junior Serestadar, that should be followed, page 102. 2015 rules, that is 2015 rules starts from
102.
79 and 102 is the qualifying method of recruitment. That is serial number 2, bottom, schedule B, part 1. Serial number 2, Serestadar, grade 1. For these post qualifying method of recruitment is
promotion.
By promotion from amongst the Serestadar grade 2 on the basis of seniority.
Yes.
This is the 102 the portion, and writ application has been filed.
But seniority date is the same.
Seniority date, date of appointment is same. Date
No,
of
your appointment has to be the seniority is to be counted from the date of appointment.
Lack of my lord PCR, that is lack of my lord confidence. That was the ACR. They said my lord, that is the qualifying service is not, my lord, confirmation has not been made. For that reason, after 6 months confirmation has been made, and in the promotion, in the confirmation letter, that was written that due to lack of qualifying confirmation, that was not done in regard to Orpita Borua.
So for purpose of ascertaining seniority, what is the reckonable date? Is it from the date of appointment or date of confirmation?
My lord, if date of appointment is same, then my lord qualification, then achievement. If that I am showing. Then my lord, page 126 is the gradation list, because initially Bardhaman was one district, then bifurcation, after bifurcation, Paschim Bardhaman and Purbo Bardhaman. That was made on 10/9/2018. Page 126 is the gradation list after bifurcation of Bardhaman.
Both of you are in the same district?
Yes, 126. My name 167, serial number 167. My name Srikanto Majhi. In the gradation list.
126 is absolutely illegible. Have you annexed a type copy?
167. No, one type copy.
167 cannot be read.
Malad, there's a from bottom 1, 2, 3, 4, 5. From bottom 5. My name is there, Srikanto Majhi. And 127, as per gradation list, he is junior to me. 196, her name, Orpita Borua. And the order starts 128. If your lordship come on to page 129, serial number 5 to 7, everything will be clear before your lordship.
129?
129. From serial number 5 to 7.
Yes.
Passed by this Honorable High Court's order. The inter se seniority between Orpita Borua and Srikanto Majhi, the petitioner herein, is not clear. It further appears that Subroto Das, the senior most in the cadre of bench clerk grade 2, has come in place of one Muktipodo Sam. The petitioner stated to have come in place of Subroto Das. There are discrepancies noted in the cadre of junior Serestadar as well as bench clerk grade 2. Orpita Borua was a scheduled tribe candidate in the cadre of bench clerk grade 2. As to how she was promoted in unreserved category in the post of junior Serestadar remains unexplained. Likewise, Amol Kumar Mukherjee is admittedly a general candidate. He has been promoted in the scheduled tribe category in the cadre of junior Serestadar. It appears that the objection of the petitioner dated 7 February 2023 has not been taken into consideration by the district judge Paschim Bardhaman. In view of the discrepancies inter alia noted by this court, it is directed that the district judge Paschim Bardhaman shall revisit the gradation list more fully set out in page 69 of the petition, being the list of names of the employee in redesignated and upgraded posts of different cadres from 10 September 2018 to 20 March 2021. The inter se seniority between Orpita Borua and Srikanto Majhi, the petitioner hearing, is not clear. It further, that is same. That is same, my lord, annexed. Then it appears that the objection of the petitioner on such as page 30. The petitioner and or any other affected candidates, including the respondent number 5, may be heard by the district judge Paschim Bardhaman in this regard. After taking into consideration all the submission, the district judge Paschim Bardhaman.
Where is the impugned order after this?
After that, my lord, the impugned order is page 154. And page 154, serial number 4, the district judge said that 50-point roster is only a mechanism for enduring reservation of the specified percentage of the vacancies in service. That is serial number 4. Then, my lord, district judge has to be followed the 50-point roster. And what will be the result of the 50-point roster after 50-point roster to be followed? That will your lordship got from page 173, page 172. What should be the procedure to follow up the 50-point roster? But serial number 4, that will be followed by way of page 172.
What is the order?
Well, that is nothing, only, my lord, they concluded is hearing, my lord, with therefore taking into consideration of least employees and respective submission of the incumbents and also the promotional order such and such, it can be said that the promotional order hereby promoting Shrimati Orpita Burua in the cadre of bench clerk grade 1 junior Serestadar is with the terms of established position of law and there is no reason to publish a fresh list.
Tell me, what is the stand taken to promote a ST candidate in the unreserved
Yes.
category? Suitable ST candidate found with effect
Yes,
as well.
page 172, my lord, kindly, page 164, my lord, kindly come to the, on my writ application, 164.
This has been brought forward. Reservation of the fourth point has been brought forward. Let them file their opposition.
May I tell you one thing?
Yes.
I tell one thing. When my learned friend, client has suppressed some things. Because blood, at the same time, he cannot blood take the hot and cold in a one time. In 2021, and this has been my learned friend, which has submitted before your lordship. But this is a normal promotional policy. But this promotion has been made in terms of the blood city commission's report. But I will disclose everything in the affidavit. But lordship, kindly hear me two things. But what happened when he got the promotion of grade 2 in the year 2023, he has accepted. He has not made any objection. Then, Lord, during the pendency of the writ petition, he has got the promotion of grade 1.
For which he is fighting.
Grade 1. Blood grade 1 in the month of July 2025, which has not challenged. Grade 1. He has not disclosed because during the pendency of the writ petition, this has been done. What has happened, Lord? At the time of giving him promotion, the 50-point roster was taken into account. More senior of him, blood, have been deprived of because 50% roster was taken into account. He has accepted that. He has not raised any objection. When, blood, this time, the 50-point roster has been taken into account, and this, blood, the private respondent has given promotion, but he's saying, I want that seniority. But this has to be decided by your lordship on it.
My lord, I am not praying seniority.
Yes.
As well as unreserved category,
It can
the
come in
candidate has been given promotion. Unreserved category.
All
How that can be?
in the previous street and in this street also, he is claiming seniority. But the settled principle is the promotion should be made on the basis of 50-point roster. It is settled. I have come with a judgment of this court and several other judgments. 50-point roster should be maintained.
High Court administration also is appearing.
When in 2000, which is suppresses, in 2025, he got the promotion in Group 1, Sarastadar, for which he is fighting. He accepted his position, where it is seen that the person who is more senior than him remain in the gradation list is
At the
lower,
bottom.
lower. But he did not accept it. So dual stand.
All right. Yes.
High Court administration is also
The effect has been kept in abeyance because this is what the previous order mentions, that the gradation list shall remain in abeyance pending consideration.
No, your lordship, kindly see your fresh report.
Fresh report.
We abide by the result of the writ petition pending.
Oh, it
But
is
it has been stated that that in view of the order dated 3rd June 2024, passed by the Honorable High Court, Calcutta, in connection with WPA 15082 of 2024, this promotion of the aforementioned employees, this promotion who has Lanfred has challenged, employees shall abide by the final result
So
of
this order was passed in 2024. The matter was required to be heard
Not 2024, the writ petition 2024.
Yes, the order that you are relying upon.
No, 25th
As
of
it
May,
promoted.
20, Lordship,
Further
kindly see,
notice be served.
25th of July,
Respective,
2025. Promotion of the second private respondent shall abide by the result of the writ petition. It has been recorded.
Please come.
Your Lordship will take up this report.
The petitioner is aggrieved by the manner in which the private respondent has been promoted. Stuff. According to the respondents, the promotion has been given strictly in terms of the 50-point roster.
Authority করেছে
ঠিক আছে?
authority
Paragraph.
বলেছে যে will abide by
The matter has to be decided upon exchange of affidavits. Stop. All the parties have entered appearance. Stop. Let affidavit in opposition be prepared and circulated within a period of 6 weeks. Reply, if any, within a fortnight thereafter.
সেটা তো চুর
Stop.
করে সেটা তো আবার সেটা তো এটা নেই ওটা অ্যাভেন্স হতো আমাদেরটা তো অ্যাভেন্স করেনি
What you are relying upon?
Sikanta Maji's promotion shall abide by the result of the writ petition.
Where is it mentioned?
Mentioned below, if your Lordship kindly see,
Which
the report
portion?
dated 23rd July, 25th July 2025, the second page.
Oh, this is the order,
Last
not
part,
the report.
The last word, second paragraph from top. In view of the order, my lord has got it.
All right. Yes.
In view of the
My
order.
client's promotion was not kept in abeyance.
No, that has not been challenged.
That is not been challenged.
That is after the order.
Video order dated 25th July 2025. The district judge Paschim Bardhaman has recorded that the promotion of the employees shall abide by the final result of the instant writ petition.
তোমাকে দিয়েছে তো 50 স্টার
Stuff.
গ্রেড তুমি তো
The
মানে 2টা পেয়েছো 3 থেকে 2
in view of the order of the district judge, the promotion
of the petitioner, my lord, that is the first.
Well, I am challenging the promotion of the respondent number 5. Respondent number 5 promotion has been given without any
the promotion of the petitioner and that of the private respondent shall abide by the result of the
Yes,
writ
yes.
petition.
Great.
কি বলছে
Respondent number 5 abide by the result of the
Yes,
Domain of the district.
district judge. Yes, yes. I do not say that High Court has anything to this.
In the reasoned order, Lordship.
এক মিনিট বলতে কি বলছে বলতে দাও।
Yes.
Shall we also file an affidavit?
If you choose not to, it's up to you.
grateful. All that matter will appear under the
Heading, liberty to mention for hearing.
Opposition by
6 weeks.
6 weeks, 2 weeks. Liberty to mention.
great.
And both the reports be kept on record.
Yes.
Very deeply obliged to us.
Order.
My lord, Mr. Shamimul Bari appear for the petitioner. He is engaged in question number 11. Kindly make it.
Private respondent. Private respondent. Day after tomorrow, my lord.
Are you filing a report?
Yes, I am filing the report.
Please
They did not file their exception.
give accommodation sought for on behalf of the learned advocate for the petitioner. Stop. A report filed by the bank be retained with the records.
I mean, applying for respondent 1
Stop.
and 2.
Released next Monday, 13th.
13th.
Next.
Report.
22 dismissed.
My lord, I am appearing for the petitioner, my lord, led by Mr. Ujjwal Rai in this matter.
My lord, I appear for Life Insurance Corporation. My lord, this
Lord.
matter was actually heard and wherein we took a maintainability point
In fact, we have filed a written notes also, but it requires further hearing on the maintainability issue, my lord. The main writ petition was challenged on the ground of revision of pay, not
May I
granted.
make submissions, my lord?
Yes, please.
What is the maintainability issue? Are you
That's why
aware?
My lord, the maintainability issue, my lord, was taken, and thereafter, my lord, kindly sees the previous order in this writ petition. Thereafter, the maintainability point was no longer pressed, and kindly sees the order.
Who
Kindly
says
seize-
maintainability was no longer? Justice Mukherjee was hearing me. We filed the written notes. My lord, the basic point of maintainability was revision of pay is not a violation of vested right or legal rights. On this aspect, my lord, we have extensively argued this matter. My lord wants to hear us again.
You want the matter to be sent back to the judge taking up the matter who heard it extensively?
My
Because
lord,
this is what
very
we say.
candid with you because I'll just give a.
This bench doesn't know what the hearing is about.
No, my lord, there is an interlinked issue because my lord will now be hearing the main matter as well. This all arising out of the development officers challenging the virus. Now, this development
That
officers
is pending before the Supreme Court, isn't
pending
it?
before the Supreme Court. In fact, my lord, I'll be arguing hereinafter. Allahabad High Court has already upheld the validity, and it has held that the rules to be intra vires. Challenging that they preferred Supreme Court before the Honorable Supreme Court. However, no stay order has been granted. Now, those matters are separate matters altogether, wherein the termination is under challenge.
No,
Or the show,
let
but
me hear
this
the
is on
petitioner.
revision of pay.
Let me hear the petitioner. What the challenge is about?
My lord, the challenge here, my lord, these petitioners, my lord, they are development officers working under the Life Insurance Corporation of India. From time to time, their conditions of service were revised and certain increments were granted in their basic pay. Now, my lord, as my learned friend is submitting, this petitioner herein, my lord, he was terminated on the basis of an amendment taken out in the rules of 2009 governing their service because their performance was not optimal as per the LICI. Now, my lord, series of writ petitions filed in this court, my lord, similar stay orders obtained. LICI will not be able to give effect to the termination order till disposal of the writ petitions. This order has been passed in case of Prolay Patro as well, the petitioner before your lordship. In a similar matter, in the revision of pay, my lord, which took place in 2024, LICI through an internal communication whereby the terming the same as guidelines for implementation of the pay revision, in clause 20 thereunder has stated any person who has brought any litigation before this honorable court or any other court or in any other honorable court challenging their termination or any matter arising out of their termination, they will not be eligible to be granted this benefit of pay revision. In a similar matter, my lord, in a writ petition, an interim direction has been passed by a coordinate bench of this court, whereby these benefits have been directed to be granted. LICI preferred an appeal, my lord. Appeal was dismissed. Thereafter, a contempt application was filed on behalf of the petitioners in that matter, my lord. In that contempt application, submission was made that arrears are being given. I am seeking the benefit which has been granted by the coordinate bench. My termination has been stayed. Also, in the revision of pay, my lord, there is already an exclusion clause whereby it is stated that any person who has been terminated will not be eligible. But my termination has been stayed. And all that has been taken into account by the coordinate bench. Appeal filed and dismissed. I am seeking benefit of this order passed by the coordinate bench in WPA 2600 of 2024. It is annexed to the writ petition. My lord, it is annexed, but may I hand out copies as well?
If it is annexed, then please do not hand over a copy.
All right.
That will only
Kindly comes
multiply
to-
documents.
Yes, kindly comes to page 164, my lord. $164, my lord, is one order, and the other order, whereby direction was given to pay the arrears, my lord, is at page 170. Kindly comes to 170. And may I place paragraph 2, my lord?
Yes.
Admittedly, the proceedings of the LICI against development officers have been interfered with by this court and various other courts, albeit and inter alia to the extent of restraining the LICI to pass final orders. Petitioners, therefore, in law are liable to be treated at par with any other employees and must be entitled to the subject pay revision. It is therefore ordered as an interim measure that all the revisions that the petitioners were entitled with effect from 2021 shall be paid as an interim measure in this writ petition with effect from January 24. The pay slips of the petitioner shall be revised and reissued accordingly. It is expected that arrears of the 2 months shall be paid to the petitioner within a period of 1 month from date. All benefits of pay revision shall abide by the final orders. Let affidavit in opposition be filed. This was taken up in contempt, my lord. And the contempt order is not annexed to the writ petition. May I show the contempt?
No, it doesn't matter. All right.
My lord, kindly comes to once, my lord, kindly comes to page 129, my lord.
Yes.
Kindly sees the proviso clause, page 18, my lord, top right, top left, my lord, there's a marking, page 18 of the rules. That kindly comes to the proviso. Provided further that development officer whose recognition had been accepted or whose services had been terminated under Rule 39. This termination has been stayed by this court. Also, my lord, the clause, relying upon which these reductions have been made, clause 20, it is annexed at page 47 of the writ petition.
Is there an impugned order in your case?
No, my lord, reductions are being, my pay slips indicate that reductions are being made.
All right.
Yes. Kindly comes to page 47. The 47 are court cases. Para 20 or clause 20, my lord, whichever way. Where a development officer has moved any court of law in a writ or other proceedings in connection with the scheme of work norms and obtained a stay, as a consequence of which we are bound to continue him or her on the same basic pay and allowances as he was drawing from the date of the stay order, these revision instructions shall not be implemented. Now, my lord, I showed your lordship page 129. Now, that is a statutory rule, and this is merely an internal instruction of LICI. It appears as though the LICI's internal instruction is trumping the statutory rule, whereby an exclusion clause has already been drafted and my termination has been stayed. I am seeking the same benefit as in the case was given in the case of WPA 8,600, 2,600, 2024. This is what I am seeking today.
All right.
Before your lordship.
My lord, may
I will similar relief
my lord,
as granted in
I
Unto of
understand, my lord,
Government.
what's troubling, my lord. My lord, first and foremost, the coordinate bench order, with deepest of respect, is not binding on my lord for two reasons. One is that the point of maintainability was not urged. My lord, I cannot be barred from taking the point of maintainability in this independent proceeding. Now, my lord, coming back to the second point, my lord, the scope of the writ petition and is not the relief that my learned is beyond the relief that my learned friend is seeking for. Because in the writ petition, my lord, kindly see the prayer. He is seeking a stay over this 2024 notification. However, this notification does not apply to him. He has been, my lord, there are few dates which are very important, my lord. Kindly take a note of the date when he was terminated. I understand that subsequently his termination has been stayed. He was terminated on 30th of September 2014. My learned friend will correct me if I am wrong. So 30th of September 2014. Now, my lord, kindly comes to page number 107, my lord. And kindly come to page 108. Similar notifications are there since 2016. On 108, my lord, would find the notification date in the middle portion once it starts with English. New Delhi, dated 14 January 2016. Now, my lord, kindly comes to page number 110. So this particular notification and the proviso provided that class 3 employees whose resignation have been accepted or whose service has been terminated under the same rule, what he is challenging now, 1960, during the period from 1st August 2012 to the date of this publication of this notification in the official, shall not be eligible for arrears on account of revision. Now, my lord, kindly come thereafter to the 2021 notification that he was showing. It further says at page 129.
If you come to 110, the
Yes,
portion that you read out just now, the proviso,
yes, my lord.
right?
Yes.
Services has been terminated. His case is that now his termination is under stay. Why
Correct.
will?
So anyone who has been terminated between 1st of August 2012 till the date of the notification, that is 14 January 2016, his termination falls within the scope of this notification. Now, my lord, kindly see what the notification further has to say. It is the similar notification time and again in 2021, because he has not annexed the entire 2016 notification. That's why I am referring to 2021. Now, my lord, in 2021, at page 131, my lord would see under the heading explanation that this equitable relief, which is, my lord, at the portion, my lord would see at 10 with bold written equitable relief. My lord, just below that, under the explanation, subclause 2 proviso, provided that no payment by way of a equitable relief shall be allowed in respect of the class of development officers whose services has been terminated under this special rules. So if someone's services has been terminated, maybe it has been stayed, but it has been stayed and it is sub judice, I understand. But if his services has been terminated into the books of the corporation, then he is not entitled for the pay revisions.
All right. Now you tell me, after stay of the termination,
yes, my lord,
is the petitioner performing his duties?
No, not at all. That's why the further show cause notices has been issued. Regularly, they are filing several writ petitions, getting a stay, just showing that the matter is pending before Honorable Supreme Court. However, Allahabad Division Bench has clearly upheld the intra.
That is different. But then he is not rendering service.
Yes. I am rendering service.
That is his case, that he is rendering service. We have
Denied
kept him in the employment
Pay.
for the reason that there is a stay order from this honorable court. Otherwise, my lord, if my lord directs me, I
If
can
that
show.
is so, then he is getting his pay.
He's absolutely getting his pay as per his basic salaries and the other things.
Then why will the revision not be allowed?
Why, my lord? Kindly comes here. There are few facts, my lord, which needs to be looked into. When his services were terminated, at that particular point of time, his basic salary was 11,535. Now, my lord, subsequent to which there has been 2 times revision. This is the third one. He has never challenged this. 2016 notification he has not challenged, which squarely applies for him. Because today, as on date, within the scope of this writ petition, he cannot challenge 2024. Because 2024 only deals with who has been terminated in 2022 till 2024. So that in this writ petition, he cannot challenge 2024. His notification that he can challenge is 2016, which he has not challenged. After that, he has not challenged 2021 notification. At this belated stage, he cannot come and challenge a subsequent notification. Moreover, the LIC has been paying him on the basis of this notification since his termination of 2014, because his salary was 11,000 certain things. So on the basis of that, now he will rely upon certain pay slips and he will show that, see, the revisions as on date is given as 57,000. After that, they are deducting. This fact also was argued, my lord, and submitted before the court, because this pay slips comes out SAP entry. Now, in this SAP entry, because of their gradations and those once it's automatically gets the basic pay gets changed because of this system. However, in order to give effect the basic pay of 11,535, there has been a contra entry of deduction of equivalent that money, so that the basic pay remains the same of 11,535, and this basic pay has been there in his account since 2014. So in 2025, when this writ petition was filed, challenging the 2024's notification, he cannot come at a belated stage and challenge this thing. Now, my lord, coming back to the maintainability issue, which was not urged, because my learned friend wants to take the umbrage of an order passed by this a coordinate bench. But my lord would very carefully see that order wherein, my lord, it was granted on an interim stage, and moreover, maintainability was not urged. So my basic maintainability point, which I want to urge, my lord, as to be my main point at the very beginning, is that revision of pay is not violation of any legal right or vested right. So if
You can revise, but not paying him the revised scale
best of
is
respect,
violation.
writ court will not
Revision
entertain.
is yours.
Writ court will not entertain revisions of pay. Termination, yes, it is violative. Writ court can, but to an extent, the revision of pay is concerned, it is a decision of executive in nature, madam. And I am fortified with
Listen, the moment you revise your pay and you make it applicable to all,
yes,
segregating the petitioner on the ground
only
that
this
he has
petitioner, all the petitioners whose services has been terminated. However, that has been stayed by this by the honorable court because of ABC reason, whatever be it.
So you apply it for the others, but for the terminated people, you do not.
Obviously, my lord. Why so? Why so?
Now that is pending, and the court has suspended the termination order for the time being as an interim measure. There, if you do not provide the revised pay, that will be
But
different.
then it will be
Revision
completely.
is definitely your prerogative. Whether to revise or not is your prerogative.
Exactly, my lord. That is my point, that it is a decision, it is a policy decision, it's an executive decision. And with deepest of respect, that cannot be challenged under the garb of a writ petition, or a mandamus cannot be sought for. Now, my lord, coming back to the other aspect, my lord, here, in fact, my lord, if my lord wants to hear me today, because I will be taking some time to argue on this. Another point that was argued of equal work, equal pay. That concept of, because they will be coming up with that judgment, and they will be relying. We have already, on the last round of litigation, when his senior was there, was arguing this matter, extensively heard, my lord. I was beseeching, my lord, I also want to do this matter, my lord, any day, my lord, fix, because I will be taking, sometimes I'll be relying upon 4 to 5 judgments on this point itself.
Judgment, everything I can
Because
see
that
is
is on the maintainability point, my lord. That has to be, my lord, with deepest of respect, my lord, I want to urge that
because
point
I
first.
can see recording of the court's order. The matter has been substantially heard, not once.
Yes.
There are several.
And we are carrying with the written notes of arguments also. In fact, I don't, my lord, it's matter being taken up after long hiatus, my lord. Whether the written notes forms a part of the court's record, I'm not sure. If not, I'm carrying the copies. I may hand up the written notes also and can then argue my matter.
If the court hears and then the written note comes in.
Very well, my lord. That would be better.
Some other honorable judge has heard it, and I accepting the written notes.
Obviously, I want to argue, my lord, before my lord, whenever.
No,
today also, my lord, I can start right now.
The parties by consent agree to have the writ petition finally disposed of instead of being hard on the maintainability issue. So
yes,
the hearing not formally
not on the,
concluded.
because without affidavits on the maintainability point, it was being argued and it was being heard.
I can see additional written notes of argument on behalf of the respondent numbers 2 and 5.
Oh,
it is
so
there.
that already forms a part of the record, my lord.
Written notes of argument of the petitioner is also here.
Perhaps the
Notes
respondents.
of argument of 2 to 5 is also
Yes,
here.
so everything is here,
on
my lord.
record.
My lord hears me any day, and thereafter, my lord sees the written notes. I think it will be easier, my lord. Because, my lord, we have already handed up the judgments, but anyways, I'm also further carrying the judgments. I'll assist my lord on this. Any day, my lord fixes it.
But then I am seriously thinking of releasing it. Please
But, my
come.
lord, I beseech, my lord may kindly not release it. Any day, give me 10, 15 minutes, my lord. Hears me, my lord. I want to
from the
argue
order.
before my lord this matter, my lord.
My lord, kindly
Next
does not
is the
release it. The main
instant
matter will also be
petition.
heard by your lordship.
Exactly, my lord. My lord may kindly not release it. Because my lord is having the determination. My lord, kindly hears me for 2 minutes, my lord.
It is only relying on the recording of the court's order that the matter has been substantially heard.
My lord, very well. That's a coordinate bench order with deepest of respect, my lord.
My lord, it was
kindly
not
don't
made part
release it, my lord. Kindly hears me why I am saying so, my lord. Because when these other matters will be coming, my lord, that 2009 development officers, there is no stay order from the Honorable Supreme Court. And we have instruction to argue the matter before my lord. My lord, that is the client's instruction. So we will be arguing. These are all interconnected. My lord may kindly not release it. My lord hears it on its own merit. I just beseech my lord, please, my lord may kindly not release this matter. And here's is any day, my lord, whenever my lord's diary permits. Yes, my lord, any day.
Absolutely inconvenient. Very difficult.
Any day, my lord, because whenever my lord's diary permits, whenever it's convenient for my lord.
It appears that the honorable judge, having determination to hear the matter, heard the same substantially. Stop. The written arguments by the parties are also on record. Stop. The hearing has not been formally concluded. Stop. The court intended to release the writ petition, but as this bench has determination to take up the matter, the parties press for hearing the matter all over again. Stop. Next. Accordingly, list the matter for hearing. In the monthly list of May 2026.
Very well, madam.
Grateful.
Grateful, madam. I'm extremely sorry for troubling my lord, but
no question of troubling. This is a matter. If you are not there, somebody else will be there. The court is here to hear matters. No issues. Yes, next.
My lord.
Your Ladyship, I appeared in item number 24.
Your lordship, I serve the notice to the respondent CSTC, lordship.
But in this matter, I am appearing for the CSTC, your lordship. I am led by Mr. MC Bihani, your lordship. The difficulty is, my lord.
Is the microphone working?
Yes, your lordship.
The green light is blinking.
Yes, your lordship.
I cannot hear you. Yes.
My lord, the difficulty is we have received the brief today morning itself, my lord. My lord, I need some time to prepare, my lord. Though the affidavit is prepared, my lord, I can file the affidavit today itself, my lord.
Who are you for?
Your Ladyship, I appear for the state in this matter, Your Lordship. On the last occasion, Mr. Ramal Sen, who generally appears for the state transport authorities, he is no more there. So, Your Ladyship, they were sought to take time. Mr. Nayan Biyani was supposed to come and appear because
the transport authority is here. What is the matter about?
Lordship, it is a matter of deduction of gratuity, lordship. From
deduction of gratuity.
After death of the employee.
After death
of the employee.
Why?
They shows the ground that there is overpayment, lordship. Lordship is a group D employee. Security
Group D employee.
Lordship.
Show me. When did the employee die? Did he die in harness?
Lordship, no.
He died after superannuation. Retired.
Before retirement, he died.
That means he died in harness.
Lordship.
Then how is the authority to know when a person will die?
Lordship, after retirement, superannuation, the wife of the petitioner made a application for informing that the employee was died, lordship. Thereafter, they issued a notice.
No, I didn't get it. What you submitted?
Lordship, after death of the employee,
yes,
the wife of the employee issued representation before the CSTC, lordship. After accepting the representation, they issued a notice, lordship. Answer 8, lordship.
Page.
Lordship, 8.
Page
14, your lordship. Page 14.
Page 14.
Page 20, lordship. Annexer 6.
Yes.
Respondent number 4 issued one memo on 6/2/2019 noticing the respondent number 5 that under subsection 1 of section 4 of Payment of Gratuity Act, read with it's up to the amendment sanction of Deputy Managing Director, conveying that the payment of gratuity is 5,39,942 only to the deceased employee Ashok Kumar Jana, who is the security guard, died on 10th May of 2018. It has also noticed that the wife deceased security guard is Suchita Jana submitted indemnity bond and related documents under this memo. It was also stated that 2 separate checks may be issued for payment of gratuity under CPF account. Thereafter, they issued 1 check in the name of the petitioner and 1 check issued in favor of the APO Belguria Department, Belguria Depot. Annexure 6, kindly see the lordship, kindly Annexure 6. Page 20, lordship.
I am at page 20.
Lordship, 2,68,846 is deducted from the gratuity, which cannot be permissible. It is the arbitrary action and violation of Article 14. I am relying on Supreme Court judgment, lordship.
Show me. Yes.
Lordship, paragraph 12. It is not possible to postulate all situational hardship which would govern employee on this issue of recovery where payment have mistakenly been made by the employee in excess of their entitlement. But that is may, based on the decision referred to herein above, we may as ready reference summarize the following few situations wherein recoveries by the employees would be impermissible. Recovery from employee belonging Group 3, Group 4 service, Group C, Group D, recovery from retired employee or employee who are due to retire within 1 year, and recovery from employee when the excess payment has been made for a period of excess of 5 years. The employee is the Group D employee, security guard.
You will fall under which clause? 1, 2, and 3 you read out.
Recovery from employee belonging to class 3 and class 4 service, Group C and Group D service.
Yes.
The recovery from retired employees or employees who are due to retire within 1 year of the order of recovery.
You are not covered by 2.
Lordship, I am the security guard.
Security guard is all right.
I am covered by the 1, lordship.
Yes.
Employee is the security guard of CSTC.
What is your submission?
My lord, kindly take it up on Friday, my lord. My senior will.
Please come. The petitioner is the widow of a Group D employee who died in harness. Stuff. Her allegation is that certain sum has been deducted from the terminal dues of the employee, which is contrary to the settled principle of law. Stop paragraph. Learned advocate representing the Transport Corporation seeks time to revert with instruction. Next Monday?
My lord, Friday, my lord.
This Friday?
Yes, your lord.
Achha, Friday. 10th.
Much obliged.
Grateful, your leadership. May the name be recorded, your lordship.
Certainly, your name will be recorded.
Grateful.
Next.
25, my lord, I am for the petitioner on the earlier occasion, your lordship directed to serve notice upon the learned advocate Mr. Rabindranath Bosak, my lord. I have served
Where is he?
My lord, today morning I had a talk with him, my lord. He told me that he will appear,
He will appear.
my lord.
All right, then you start. Let us see whether he appears or not.
My lord, this matter pertains to, my lord, these petitioners were working as tube well mechanic, my lord.
Tuber?
Tube well mechanic
Tube well
on
mechanic.
contractual basis, my lord. My lord, they were treated as Group D workers, my lord. And my lord, they were receiving a lump sum amount of 7,890 as monthly remuneration, my lord. And they were working since 1998. And my lord, a notification was published by the respondent authorities. Kindly,
You want the benefit of 9008?
my lord.
Has any decision been taken by the
My
authority?
lord, on the earlier occasion, or before it was heard by the honorable, on the earlier occasion, it was heard by the honorable justice, my lord, wherein the state told that we are taking decision to solve the dispute, my lord. Kindly see.
Then what happened?
Thereafter, nothing, my lord. The
Nothing.
matter. And my lord, subsequently, my lord, we have filed a supplementary affidavit on the earlier occasion, my lord, wherein kindly, if your lordship uses page number 6 of the supplementary affidavit, my lord, the district panchayat rural and development officer Bankura, my lord, forwarded a letter to the special secretary to the government of West Bengal, wherein it was requested to allot funds in respect of us, my lord. But then also nothing. The petitioner's salary has also been stopped, my lord.
Why?
My lord, due to filing of this writ petition, salary
Is
has
he permitted to work or the service terminated?
no, service has not been terminated. We have been stopped from salary. Salary has been stopped.
Since when?
Since
The writ
July.
petition was filed in 24. How much are you getting?
My lord, 7,890. This is the amount we are getting, but we are claiming parity in respect of the notification,
Yes, that I understand.
which we are supposed to get 39,000, my lord, as monthly remuneration.
And you are getting 7,000.
7,890, my lord.
Please come. None appears on behalf of the state. Despite service of notice to the learned advocate representing the state respondents. Stop. The petitioners are serving. How many are there?
My lord, I have submitted the deficit court fees, my lord. 6 are there, man.
Achha, the petitioners are serving as tube well mechanics in various gram panchayats. Stop. They seek service benefit in terms of the memorandum number 9008-F within bracket P dated 16th of September 2011 and the amendment made thereto, not amendment, and the updated memorandum, the last being 1st March 2024. Step. Paragraph submission of the petitioners is that they were receiving a paltry sum of rupees 7,800 per month. Stop. They ought to be paid rupees 39,000 per month in terms of the last memo dated 1st March 2024. Stop. It has been submitted that as the petitioners filed the instant writ petition before the court, their monthly remuneration has been stopped. Since when?
Since 2024 July.
How are you all serving? You filed the writ petition in November, not in July.
Just after filing the writ petition, my lord, our
after filing of the writ petition, their salary has been stopped. বললাম তো remuneration. ঠিক আছে? Paragraph, the court video order dated 19th of February 2025. Adjourned hearing of the writ petition on the prayer of the learned advocate representing the state. Stop. The stand of the state is very much required to be brought on record. Stop. The additional chief secretary, finance within bracket audit, is directed to file a report by way of affidavit disclosing the stand of the state apropos the prayer of the petitioners. Stop. Such affidavit shall be made ready and circulated by 22nd May. Release the matter on 15th of June. Stop. Let this order be communicated to the aforesaid respondent and also to the learned advocate representing the said respondent. Notice of the learned advocate of the petitioner addressed to the learned advocate for the state be written with the records. Stop. Deficit court fees, please.
My lord, I have paid, madam.
Receipt showing payment of deficit court fees be written with the records.
It is also reflecting in the case status, madam. It is also reflecting in the case status, madam.
Oh, then it's all right. What it take to happen, Degi?
Yes, my lord. I appear on behalf of the CSC, my lord. This is that matter wherein, my lord, regarding to service, my lord, where I stated the CSC
The
doesn't.
petition is not
Yeah,
maintainable.
it is not maintainable,
My lord, was directed the petitioner to come prepared regarding the judgment having handed over to your lordship on the last occasion by CSC, my lord. My lord, that judgment,
No, I have a copy of the judgment.
No, I am, no, lordship, I am filing a judgment of Honorable Supreme Court,
Yeah.
my lord, in read jurisdiction. The earlier judgment that has been supplied by my learned friend was about whether the CSC coming under the definition of state under Article 12 or no.
No.
As per paragraph 5 and also
It is certainly a state, but not in respect of the service matters of the
service matter, my lord. My lord, service of the employees, my lord. My lord,
I have single bench decision and also division bench decision decided in 2007.
Let me see what the petitioner has to say. Yes.
My lord, this is a judgment of Honorable Supreme Court, my lord, passed in 89, my lord. 89 to SCC 691. My lord, kindly come to paragraph.
No, this Andi Mukti is a very old judgment and everybody is aware of it.
Thereafter, my lord, 2005, my lord, this judgment was again relied in 2005 Z Entertainment.
Yes, Z Entertainment, yes.
My lord. In that judgment also, this judgment was.
Tell me whether this relates to service matters of the private company or not.
My lord, this CSC is in public duty, my lord. Now
this is not your service is not a public duty.
No. My service is under the authority, my lord.
Yes.
My service is under the authority and the dispute is my lord relating to violation of my right, my lord.
Yes. So it's not maintainable.
My lord, the dispute is relating to
this judgment paragraph 7. This is a division bench judgment of 2007. My learned friend's answer will be given.
Yes.
My grievance was that, my lord, when I joined the service, they have stated that your age is, they have determined by their self, as I have no documents at the relevant point of time, they have stated that your age is 1964. Your age is determined as 1964 by their medical board, my lord. Now, my grievance is that, no, my age is 1970 and I have government documents over this. Now, my lord, the thing is that the service matter in before the authority, whether this is on the violation of my rights or not, that needs to be determined by this honorable court, my lord. Because the 89 judgment, my lord, paragraph 20 is, if your lordship kindly allow me to, because the scope of article 226 is not limited, my lord, to the service or before the authority or not, in violation of my rights regarding my service. Their determination was by their medical board. My prayer is very limited, my lord, that my age should be determined further.
Very well. Please come. The petitioner is an employee of CSC Limited. Stop. He is aggrieved by the manner in which his age has been assessed by the medical board of the authority. Stop. Not the learned advocate for CSC Limited raises an issue with regard to the maintainability of the writ petition. Stop. The reliance has been placed on the judgment delivered by the court in the matter of এই যেটা লিখবেন তো আগের দিন লিখেছিলেন পথিক চন্দ্র বিশ্বাস and আচ্ছা আগে এটা দেবেন ডিভিশন বেঞ্চ IB Enterprises versus CSC Limited and others reported in AIA 2007. পথিকটা রিপোর্টেড সেপারেটলি, এটা হচ্ছে আইবি এন্টারপ্রাইজ 2007, এটাকে আগে দেবেন তারপর পথিককে নিয়ে আসবেন, ঠিক আছে? The court consistently held that this pothik was regarding some
Land dispute.
license regarding the tender
Sale of
matter.
land.
This is the tender matter.
matter, but the public element in respect of dealing with the CSC has been explained in paragraph 7.
My lord, 89 judgment is about service law, my lord. And that has been reaffirmed in
That under Article 226 of the Constitution, the writ petitioner must show that any of his legal or fundamental rights is infringed by the action or inaction of the state within quotes. The court held that the respondent authority was discharging the duties cast upon the Electricity Act 2003, and therefore it cannot be said that there was any public element in the sale of the property. Stop. The court noted the previous judgments relied upon, consistently holding that CESC, when not discharging its duty as licensee under the Electricity Act, cannot be said to be state within the meaning of Article 12 of the Constitution. Stop. The court took into consideration the judgment in the matter of Pothik Chandra Biswas within bracket Supra. Stop. In Pothik Chandra, the court clearly laid down that the internal management of CESC Limited is private and the writ court cannot pass direction with regard to the same. Stop. Paragraph. The petitioner controverts the stand of the CESC Limited by relying on the judgment passed by the Honorable Supreme Court in the matter of reported in such and such. And which portion are you relying upon?
Paragraph 20, my lord.
20. Wherein the court held that Article 12 is relevant for the purpose of enforcement of fundamental rights. The words any person or authority within quotes, any person or authority used in Article 226 is not to be confined only to statutory authorities and instrumentalities of the state. They may cover any other person or body performing public duty. What is relevant is the nature of the duty imposed on the body. Stuff. Paragraph. In the instant case, CESC Limited performs public duties, but the dispute of the petitioner is not relating to any public duty. Stop. The dispute is absolutely an internal dispute between the employer and the employee. Stop. The service matter of an employee of the CESC Limited cannot be adjudicated by the writ court in terms of the decisions passed in the matter of IB Enterprise and Pothik within brackets Supra. Stop next. In view of the above, the prayer of the petitioner cannot be allowed. The writ petition stands dismissed. It will be open for the petitioner to approach the competent forum for relief in accordance with law if so advised.
I'm grateful, Lord.
My lord, item number 27, senior counsel Pramod Kumar Roy is appearing. If you may hear it.
Can it be taken up on next week? I'm for the petition.